A teraz...
Mamy przegadane, tylko czy...
Czy teraz mnie słychać? I czy słychać dobrze? Jest ok? Dobra. A, wyciszę go. Okay, thank you. Our technical crew is saying that we can start, so we will. Sorry for the short delay. We are still arranging the first panel. Our speakers are getting connected, so we will shortly begin. I think this event is prepared and organized by two institutions. One of them is the one where we are today, that is the Polish Academy of Sciences, the Institute of Legal Studies, and more particularly with the New Technologies department here. And the other institution is Adam Mickiewicz University, the law department of the Adam Mickiewicz University in Poznań. Why the CDSM directive? The answer is probably obvious. We are in the middle of implementation process. Poland has not yet implemented the directive. Some of the other countries have. The proposals from the other countries are on the table now. They're being discussed and raise a lot of interest from various stakeholders that are involved in the process of implementation of that directive. And it's truly a big event, you might say, a landmark directive for the copyright world or for the digital world, because what it seems to be is that it's an overhaul of the consensus that we've had for many years since the beginning of this century, or the end of the last century and beginning of this century. The consensus that we had with the Infosoc directive, the e-commerce directive, and this consensus seems to be shaken now with the proposals coming from the European Union with the CDSM directive. And that is why it's definitely a serious matter, because it will define the way we do business in the digital world in the years to come. Therefore, I'm sure this is it's important to have a discussion and to have a cross-border discussion and to learn from colleagues from outside, from other jurisdictions, as to how they approach the problems posed by the directive. We've divided our program today into three probably most hotly debated issues. Not surprisingly, the first panel will be devoted to Article 7, to the implementation of Article 17. This certainly raises a lot of attention from all of the circles involved here, all of the stakeholders involved here. The second panel will be devoted to something that is also controversial, namely Article 15 and the press publishers' rights. And the third panel will be devoted to exceptions and limitations in the new directive. We've left some of the issues from our discussion, namely the provisions in the directive on copyright contracts. Though they're quite important, I must say. This is where the Commission, where the EU legislator preaches the virtue, the value of transparency in the contractual relationships between the right holders and the acquirers, licensees and licensors. So transparency is an important value in that part of the directive, but it seems that it's easier to preach transparency than to have transparency, than to get transparent regulations once you're proposing something. Therefore, Article 17 certainly to a reader, even to an experienced copyright lawyer, is not easy. To read, and its transparency is certainly can certainly be questioned. So, since the provisions on the contracts are of different species, We will leave them out for today, but certainly that's an important field of harmonization in the European Union copyright legislation. We'll be moving to the first panel now. I will briefly present the speakers for the first panel. We have four very distinguished guests today. Joao Pedro Quintais, Professor Christophe Geiger, Bernd Justin Jutte, and Martin Husovec. They will appear, I mentioned them in the order of appearance today. I will briefly say a few words. You probably know them. They have written extensively on the various aspects of the Copyright and Digital Single Market Directive and provided us with in-depth analysis of the various problems that these provisions, particularly Article 17, poses. So to begin with, Joao Pedro Quintais. Joao is an assistant professor at the Information Law Institute in Amsterdam, the Netherlands. His research areas, his interests are vast, but just to name the leading, I would say that, first of all, Joao researches the area of how IP law applies to new technologies, various new phenomena like peer-to-peer networks, streaming, hyperlinking, blockchain, artificial intelligence. Secondly, Joao examines the implications of copyright law and enforcement on internet users' rights and freedoms. And finally, he assesses the role and responsibilities of large-scale platforms, especially in the context of algorithmic content moderation of user-uploaded illegal, harmful content. Our second and third speaker will have a joint presentation, and that will be Professor Christophe Geiger. Professor Christophe Geiger is a professor at Guido Carli University in Rome, previously a director at the Center for International Intellectual Property Studies in Strasbourg. He was also, is today an affiliated researcher, senior researcher at the Max Planck Institute for Innovation and Competition in Munich, as well as the Spangenberg Center for Law Fellow at Case Western University in Cleveland, Ohio. He has extensively written on this issue and previously has very extensively written on that intersection of intellectual property, copyright law, and fundamental rights. He has lectured in various top universities, Harvard, just to name a few, New York's University School of Law, Cambridge University, Copenhagen, Ludwig Maximilian in Munich, and I could still name a few others, but we'll leave it at that. He's also a consultant to various institutions, European Parliament, and European Intellectual Property Office, just to name the few. Our third speaker today will be Bernd Justin Jutte, who is an assistant professor at the Sutherland School of Law at the Dublin University College. That institution he joined last year after obtaining LLB from Greifswald in Germany and a master degree and a PhD degree from the University of Luxembourg. Justin is also an expert in this area of digital copyright law, and also a person that has very extensively written and commented on IP, copyright, and fundamental rights. One of their publications is together with Professor Christopher Geiger, and deals specifically with those issues. Our fourth speaker today will be Martin Husovec, who is an assistant professor at the London School of Economics. Martin holds a PhD from Ludwig Maximilian University and Max Planck in Munich. He has been an assistant professor at Tilburg University for 5 years, from 2015 to 2020, and also is held also various appointments at Stanford, Japanese Institute for Intellectual Property, CEU University, and is a fellow at Stanford Law School Center for Internet and Society at CREATE and at TILEC in Tilburg as well. So I think if we do have, if our panelists are ready and we've managed to pass all the obstacles, and I'm informed that we are, so we will move to Joao, Joao Pedro Quintais, who will give us an introduction, an overview, state-of-the-art information, and will provide us with the presentation of main issues relevant to the discussions surrounding Article 17 of the Copyright in Digital Single Market Directive. If I may, I will now give the floor to Joao. All the participants online and here, there are not that many on site, but as far as participants online are concerned, you can write your questions. We will collect them and we will present them to the speakers after their presentations. So feel free to comment, ask questions. We will do our best to forward them and to include them in our discussion following the lectures. That's so much from me. Once again, warm welcome. We're happy to have you, and I give the floor to our distinguished speakers.
Can you hear me now?
Okay. Joao, can you hear
Amazing.
us?
Perfectly well.
Glad to have you. Thanks for accepting our invitation and acting on such a short notice. Always ready to preach good copyright law. So thank you very much. And we're very much looking forward to your overview of the most relevant issues.
Perfect. Well, it's a pleasure to be here. Let me put my headset. There's a little bit of a feedback loop, I guess, from the room there, but if that cannot be solved, there's not a problem. So it's a pleasure to be here and a pleasure to be on this panel. It's a new technology we're using here, which looks pretty cool. Always good to check it. So what I will do here is a little bit of a lengthier introduction to what we're going to be discussing in this panel today, and I'll try to tease out some of the issues that then Martin, Justin, and Christophe will discuss later. And I'll try to be as neutral as possible, but I'll cover quite a lot of ground because I think we need to have a good baseline understanding of what we're talking about here. So I'll firstly discuss timeline, give us a little bit of state where we are now, although this is changing daily. Then I'll cover the complex regime of Article 17, and then finally on to preventive measures versus user rights, which is, I would say, the hottest topic within Article 17. So as far as timeline goes, if you squint your eyes enough at your screen, you will see that we have quite a complex picture. And this complex picture is a picture of, on the one hand, multiple proposals being developed at European level, most notably the Digital Services Act. But since May 2019, we have a directive proposal that has been at an implementation deadline of June this year. Now, at the same time as this has happened, we have two important developments, I would say, or three. One of them was that, as per Article 1710, the European Commission had to come up with the organized stakeholder dialogues and come up with a guidance. That guidance implementation of Article 17 came out one working day before the implementation deadline, as caused member states to wait for it, and therefore one of the main causes of the delay. At the other level, we've had the Polish government starting an action for annulment against Article 17 as a whole, or part of it, which one we'll discuss a lot today, especially the following speakers, but also myself a little bit. And on that particular case, the main issue is whether the balance struck by Article 17 within its internal mechanism is compatible with the fundamental right to freedom of expression. And finally, quite ironically, we've also had this development of interpretation of Article 3 of the InfoSoc Directive, the right of communication to the public, especially a stream of cases ending up with YouTube Siendo, that in simple terms discusses, do we need Article 17 at all, or do we have actually this whole thing covered, especially vis-a-vis platforms like YouTube, by Article 3? Now, this kind of complex reality is where we are right now, right? With multiple member states delayed in the implementation, we have the AG opinion on Article 17, which we'll discuss, and we have the case decision in YouTube and Siendo that basically says, as a matter of principle, YouTube, under its current design, is not liable for direct communication to the public, as it's instead benefiting from the hosting safe harbor in Article 14 of the e-commerce directive. At the same time, the Commission has sent letters of pre-infringement procedure against many member states for non-implementation, which is on the one point understandable, on the other side not, since the Commission itself is to blame for much of this delay, at least in its guidance. Now, where we are right now, as I said, is changing. I updated this 3 days ago with the Comunia's website database, but as you can see, most countries have not adopted into national law the CDSM directive, and most of them have not adopted or have a clear provision on Article 17. Comunia itself has developed this funny implementation status as a Eurovision contest, and as you can see, for the most part, we're still developing national implementations. Now, I think what needs to be said is that despite the guidance having come out, from the implementations we've seen so far, the ones that came before the guidance obviously don't really take it into consideration, and the ones that have come after are mostly a verbatim copy of Article 17, thereby ignoring many of some thoughtful, some criticizable aspects of the Commission guidance. So one is left to wonder what role this guidance will actually be having in the future. Now, if that is more or less clear, we'll go into the mechanics of the provision, and I'll try to tease out some of the issues we'll be discussing in this panel, and also feel free to put some questions in the chat on this point. I think there are we can group this into two different. The first one is to what type of service providers does Article 17 apply to? And the second one was what's the scope and liability of the provision? So as to the first question, Article 17 applies to what can be seen as a subtype of hosting service providers, so-called online content sharing service providers, what I always consider terrible acronym of OCSSPs, which we'll be having to live with for the foreseeable future. There's a positive definition of what OCSSPs are, designed more or less around the concepts that were already present in intermediary liability case law at the European level, but also in direct liability case law for Article 3. So it has to be a user-generated content platform or user upload platform, hosting large amount of works that it organizes and promotes, and some sort of competitive or commercial effect. So clearly applying to the major video sharing platforms, not so clearly to other types of platforms, but we can also discuss this if you wish. There's then a negative definition that excludes a number of players that may not meet some of the main criteria of the primary definition, the positive definition, but importantly, some of them have also been lobbied into this provision of the CDSM directive. That's Article 2.6, where you can find this. Now, the crux of the matter here is that you either qualify as an OCSSP or you do not. If you don't qualify as an OCSSP, you are, for lack of a better term, a non-OCSSP platform hosting copyright protected content. That means that you are not regulated by Article 17. You're regulated by the regime in Article 3 InfoSoc Directive and Articles 14 of the e-commerce directive, to be replaced by Article 5 of the DSA. That means that you are basically subject to the case law of the court up to YouTube Siendo. And that, in my view, is different, or it's clearly different from what is in Article 17, despite some similarities. So you have this bifurcation of legal regimes that is now the new norm. Funnily enough, the main platform that gave rise to this YouTube Siendo case, YouTube, is now clearly an OCSSP, whereas under the previous regime, it would not have been directly liable for communication to the public. So this is who it applies to, the provision. The question that comes after is the what and how, the scope and liability. If you are an OCSSP, then the new regime is that you're communicating works to the public, independent of knowledge or illegality of the upload. So different from the YouTube Siendo line of case law, you are subject to direct liability. You're sort of a copyright user, for lack of a better term, a Netflix or a Spotify of sorts. And you are excluded from the hosting safe harbor in Article 14 of the e-commerce directive. So this is lex specialis to the e-commerce directive, but obviously, and now by recognition of the Commission itself in its guidance, this reality is different from YouTube and Siendo and the reality of Article 3. So Article 17 of the CDSM directive is also lex specialis as regards the exclusive right or the right of communication to the public it has. It provides in relation to Article 3 of the InfoSoc directive. So there's a lot of lex specialis going on here, but mainly it's basically a different regime, if you want to put it in simple terms, that follows its own rules specified in Article 17 and whatever the court will say later. Now, you are not directly liable.
Natomiast nie ponosi się tutaj odpowiedzialności bezpośredniej, czyli żeby jej uniknąć, trzeba najpierw uzyskać uprawnienia dotyczące całości bądź większości treści ładowanych do takiej usługi. Komisja zakłada, że to się zawsze będzie dało uzyskać, natomiast nie wiemy jeszcze, jak to się idealnie rozegra we wszystkich krajach członkowskich. Natomiast takie uprawnienia powinny obejmować użytkownika ładującego tam treści w celach niekomercyjnych bądź komercyjnych, ale bez generowania istotnych przychodów. Znowu ta istotność przychodów będzie się musiała jakoś utrzeć w praktyce. Jeżeli takiego upoważnienia się nie uzyska, to jest drugie wyłączenie, czyli mechanizm wyłączenia odpowiedzialności z artykułu 17.4, warunki, które trzeba spełnić łącznie. Pierwszy to poniekąd analogicznie do uzyskania takiego upoważnienia, czyli podjęcie należnej staranności, żeby takie upoważnienie uzyskać, więc jeśli nie uzyskamy tego upoważnienia, to musimy przynajmniej wykazać się należytą starannością na drodze do jego uzyskania. Tutaj w wytycznych jest bardzo wiele szczegółów na ten temat. Mamy też wiele opinii na temat ich potencjalnej skuteczności bądź jej braku. Natomiast oczywiście tutaj się trzeba jakimiś działaniami wykazać. Jak na razie przepisy wdrażające nie są bardzo spójne czy bardzo jasne, jeśli chodzi o to, w jaki sposób ta należyta staranność miałaby być harmonizowana w przepisach krajowych. Poza należytą starannością należy również dokonać koniecznych czynności, jeśli chodzi o określenie właścicieli praw autorskich. To się często kończy filtrami ładowania, taką prewencją ładowania treści, co do których te prawa byłyby niejasne.
Notice and takedown and notice and stay down system. And the notice and stay down system is often referred to critically as imposing an obligation to have re-upload filters on platforms. Now, this is the basic setup of the first part of the article. Now, when you turn the page, then there is a number of mitigation measures that are embedded in Articles 17.5 to 17.9 that try to claw back some of the excesses that might be caused by this very strong approach to liability and liability exemption within Article 17. And those are proportionality assessment and factors that must be taken into consideration when applying the preventive measures, a new regime for mitigated regime for small and new OCSSPs, then the imposition of user rights or mandatory exceptions and limitations, a restatement of the ban on general monitoring that already came for Article 15 of the e-commerce directive, and safeguards for complaint and redress mechanisms in and out of the platform in Article 17.9. Now, the crux of the discussion is in the latter three, and this is what we're going to discuss a little bit also in the following part of my presentation, but also in Justin, Christophe's, and Martin's presentations, is how do we balance this out? How do we make sure that the provision is internally balanced, but also externally balanced with fundamental rights? Now, in this discussion, I'm going to frame it for you, and then we can go into the details in the next presentations and also in the Q&A. Now, what's the internal mechanism for balancing preventive measures versus user rights and safeguards? I think the first point is that there is a normative hierarchy in Article 17. In this, what Martin Senfleben calls the Bermuda Triangle between the entitlements of rights holders, platforms, and users, there's clearly a different nature of obligations. So whereas the preventive measures that are imposed in the provision are obligations of best efforts, the user rights and freedoms and safeguards, or especially the user rights as mandatory exceptions and limitations, are designed as obligations of result. This has been recognized by all the major institutions, and it's also clear in the EC guidance and in the AG opinion in the Polish challenge. This has consequences, and I'm going to try to just illustrate them briefly before we move on. So what are the consequences to address this reality? Well, the consequences is that when you get into the application of the liability exemption mechanism, you are faced with the reality that to impose, to comply with the best efforts obligations on sublets B and C, so the filters and the notice and stay down especially, you need to apply content recognition technologies. Now, there are requirements that the Commission has tried to nuance in its guidance, and I'll provide the slides afterwards, so no need to go to the details here about the type of information the rights holders must provide. But all of this basically means, in the Commission's view, that tentatively, the best solution for platforms from a certain size up is to employ filtering technologies. And those are mostly based on matching algorithms. So they are not really capable of recognizing context, assessing context or nuance that is required by the types of quote-unquote transformative uses that are required under the obligation of result of paragraph 17.7. So that means that the type of national implementation that only ensures users have right to complaint and redress mechanisms, so only ensures ex poste sort of redress by users, is not sufficient to comply with the requirements of Article 17.7. Now, this has been recognized now both by the AG in his opinion and by the European Commission in its guidance. And simply the main issue is incompatibility with freedom of expression. If the current state of the technology is such that it's mostly based on matching algorithms that cannot recognize any of the uses that is identified in Article 17.7, they're not designed for that, then we have to create a sort of nuanced approach that should safeguard these rights because they are of a higher level than the obligation to comply with preventive measures. So that's the basic gist of the argument. So how to do that? Well, the way to preserve this hierarchy has been twofold in the Commission's view. One is a nuanced interpretation of what constitutes this preventive measure. So if you go to the guidance, the Commission goes to great lengths and pains to say, how can we use the proportionality assessments and factors to comply with these obligations, taking into consideration this reality of the technology? But also there's a major decision here, which is we need some sort of ex ante safeguards. So the main thrust of these ex ante safeguards in the guidance is to develop and identify two categories of content for which the application of preventive filtering is acceptable. So we can use these rough technologies in this field for two types of content, either manifestly infringing content or earmark content. And importantly, they mostly do not overlap. And I know Christophe and Justin are going to some detail on this, at least in their presentations. So I just want to leave this idea out there, or this notion that there are these two categories of content, one of which aligns more or less with the case law, the one on manifestly infringing content, depending on how we interpret it, and that the Commission still has quite a broad view of what this is vis-a-vis transformative uses. And on the other side, this new category of earmark content that is some sort of high risk of economic harm content that rights holders have significant leeway to tag in the platforms, to identify, and then that will be filtered out, but which is not necessarily or usually not manifestly infringing content. And it's against this type of reality that the Advocate General, which wrote most of his opinion before the guidance was out, but still added a postscript at the end of the opinion, said, no, this is actually not compatible with freedom of expression. On the one hand, in my view, the Advocate General said these measures are only permitted for manifestly infringing content, which is, in his view, as I read the opinion, more strictly defined. This is why I've designed it like this here, than the category of the Commission. But the Advocate General goes a step further and says, in addition to this, I don't think my considerations in this opinion are compatible with accepting that preventive filtering can be used with the current state of the technology for earmarked content that is not manifestly infringing. And so from my perspective, this is kind of the main point of battle from the freedom of expression perspective. And what I would say is that we have gone a long way from accepting the use of content recognition technologies for preventive filtering for a lot of types of content to this more freedom of expression mindful approach of only accepting those measures for a type of manifestly infringing content. Whatsoever defined, we still have to discuss that. So I would end my presentation here and would be very happy to hear your questions, but also to hear the thoughts of Christophe, Justin, and Martin. Thank you very much.
Thank you, Joao. Thank you for the interesting presentation and for the introduction and setting the stage for further discussion. I think we will move to questions and possible questions. We'll move them to the end, and we'll now ask Professor Geiger and Justin Jutte to give their joint presentation related mostly to a large extent to the Polish challenge and the issues arising in the Polish challenge to Article 17. Christophe and Justin, the floor is yours. You decide who starts first and who is the second speaker. Do we have connection with? Okay, I think we're still trying to connect to our second and third speakers.
I think you're muted, Christophe and Justin.
Okay.
Because I'm not familiar with this system. How to unmute?
We can hear you now. We can hear you.
Okay. Great. So it's not us. It's actually centralized sound.
Oh, thank you. I can see you now at least. So if everything is technically fine, I give the floor or the microphone on, or whatever we should say in this online context, to Christophe and Justin. Thank you for being with us.
Well, if I might start, thank you very much, Professor Sikowski. Yeah, the slides are there. So basically, I will just say a couple of words and then hand over to Justin. Joao has done an excellent job to introduce the issues. We have a bit more time, I understand 40 minutes. So of course we'll be able to dig a little bit deeper in many of the issues that were just mentioned. The point that we will talk about the challenge to Article 17 before the Court of Justice. And I hear some very bizarre sounds. It seems to work now. So we will speak about the challenge, but of course the challenge is based on fundamental rights. So we will expand a little bit the discussion about Article 17 in the light of fundamental rights. in the challenge, but we will also go a little bit beyond that, because we think that some of the fundamental rights arguments were not raised by Poland in the challenge, and so we will address them because they might play a role at a later stage, and particularly when coming to apply Article 17 in court. And so we will expand on the fundamental rights reasoning, and then we will, of course, dig a little bit deeper into the different documents that were just mentioned, guidance, YouTube and Siando decision, and then also the opinion. And we're gonna make some proposals based on actually two papers that we have written together, published this year in Gros International and in European Intellectual Property Review. So our main message, and I will summarize it very quickly here, is that Article 17 as it stands has a very major fundamental rights issues, and it would be possible to basically come to the conclusion that it's not compatible with the Charter. And if it happens to be the case, then it's not so dramatic, because we can see that the framework that was built via a combined reading of the guidance, the YouTube Siando decision, and the opinion of the Advocate General sketch out already a quite interesting and balanced framework and flexible framework to deal with the issue of Article 17 at the end. And if we want to have a legislative intervention, why not maybe catching up the discussion in the Digital Service Act, which deals also with platform liability for content, and to basically come up with a horizontal approach like it was in the past with the e-commerce directive. So this is a little bit what we're planning to do, and I will hand out to Justin to sketch out the main fundamental rights issues in the challenge.
Okay, wonderful. I hear me now. If not, give me. First of all, thank you, Christophe, for the introduction. I'll pick it up from here, but I also thank Professor Sikorski for having us today. Joao for the very good introduction, which helps us a lot. And I also thank Martin, just so he doesn't feel excluded. So the structure we'll be following is I'll start with giving a bit of a background to the challenge, what the challenge is about, what the question actually is the Court of Justice is supposed to answer here. And of course, this is not a preliminary reference, it is an annulment procedure before the Court of Justice. I'll provide a bit of the background on the legal context, and then I'll map out the fundamental rights and their substance that are at stake here. And then I'll hand afterwards over to Christophe to go into the meat of Article 17 and fundamental rights. So in essence, Poland in 2019 suggested with its action for annulment that Article 17, at least certain parts thereof, are in violation of the right to freedom of expression, because Article 17 would require from OCSSPs to install filtering mechanisms that would ex ante prevent the upload of certain material, copyright-protected material, which would then lead to a suppression of speech. Our argument is much more extensive. We argue that not only Article 17.4 or the points that Poland argues are in violation of freedom of expression, but Article 17 as a whole is in violation of a number of fundamental rights. But indeed, Joao has already presented us the entire enormity of Article 17. The challenge only relates to what you can see here on the slides, to the lower parts, to the red parts, namely elements of Article 17, paragraph 4, that will or that would suggest that OCSSPs will have to filter, that they will have to ensure the unavailability of specific works and subject matter on online content sharing service providers, and also to ensure that once such content has been blocked or taken down, will not appear on the platforms in the future. So the claims under the Polish challenge are twofold. The main claim is that Article 17.4b and Article 74c in fine, so the latter part, are in violation of Article 17 of the right to freedom of expression. But there's also an interesting part which is often overlooked, that Poland argues that if taking Article 17.4b and 17.4c out of Article 17 wouldn't result in a legal construct that in itself would be stable, Article 17 in its entirety should be annulled, taken out of the directive, and not be considered to be good law anymore. And this is kind of like the direction in which our argument is going. But we need to widen the scope of the analysis a bit beyond freedom of expression, also including other fundamental rights. So to summarize, Poland argues Article 17.4, parts thereof, or Article 17 in general violates the right to freedom of expression, and therefore it should be deleted. We will suggest there is a much more complex interplay of fundamental rights involved, at which we will have a look now. One thing that we should be reminded of is that historically and consistently, the Court of Justice has argued from the very, very beginning of the case law, and this is really only one of the examples, that any limitation of a fundamental right, in this case freedom of expression, of course, is in principle permitted, but such limitation cannot attack the essence, or any limitation must respect the essence of the rights and freedoms that are being limited. And if such a limitation touches upon the essence of the fundamental rights, that would go too far and would constitute an unjustifiable limitation of the fundamental rights in question, and would not result in a fair balance between the various rights and freedoms considered. And one thing that we also have to keep in mind, this is of course a bit theoretical, is that there is no hierarchy between the various fundamental rights that we can find in the Charter or the Convention, which we also of course have to have a look at. And we had cases before the Court of Justice where balances between multiple fundamental rights have been discussed. One example, the recent Spiegel Online case, but also the majority of the enforcement case law, Scarlet Extended, Network, and so on and so forth. We saw how the Court of Justice, relatively superficial, but nevertheless tried to balance online copyright enforcement against the background of a variety of fundamental rights. Here we suggest the mixture of fundamental rights is a bit more complicated. One might even want to say it's a bit more toxic. And we will demonstrate in relation to a number of fundamental rights that there are indeed problems with the essence of the fundamental rights. But in general, if we talk about such a complex situation here, any interpretation should seek to find not an ideal, but an appropriate balance between the fundamental rights involved, which isn't always possible, but all the fundamental rights should at least be preserved in their core. And the rights we talk about specifically are mainly 5. Article 17 touches, as Poland suggests, and quite obviously, the right to freedom of expression by potentially filtering online content that should not be filtered. Attached to this will be the right to privacy. Online filtering mechanisms will deal in personal data. This is a problem that has to be considered. OCSSPs will incur additional obligation, which touches upon the right to freedom to conduct a business. The right to fair trial when it comes to appeal mechanisms, to erroneous blocking orders, will also have to be considered. And most importantly, or not most importantly, but on the other side, as a counterweight to all these fundamental rights, of course, we cannot forget that for right holders, now the entire purpose of Article 17 is the right to property, to ensure that the right to property can be properly exercised in an online environment and on OCSSP platforms in particular. However, the Polish challenge, and this is one of the dangers, is limited to the interplay between users and their right to freedom of expression. And of course, one problem here is that the Court of Justice, in most of the cases, tends to answer the question it is being asked and doesn't stray much beyond the analysis it is expressly asked to conduct. But we suggest that the Court of Justice might or should look into other fundamental rights. Whether it can do that or not is a completely different question. If you look at the opinion on the challenge, the Advocate General relatively closely stuck to the interplay between the obligations arising out of Article 17.4 and the right to freedom of expression. But we'll also look into these other areas that on this slide are marked in a light orange. So going back to the substance of Article 17, one important thing is that Article 17 cannot be looked into, 17.4 cannot be looked into in isolation, because Article 17, as Joao already demonstrated, is a complex interplay. It has internal hierarchies that we also have to consider. But one thing to, it's important to understand when we depart towards our analysis is that there is almost unanimous consensus that Article 17.4 will require online platforms to install automated filtering systems. Just looking at the scope and the amount of information that will have to be processed to be checked against infringing uploads will eventually require the installation of automated filtering mechanisms. Otherwise, the task simply cannot be managed. And I personally haven't read a single submission which stated that there is any other way other than automated filtering mechanisms. And the Court of Justice has also recognized this in YouTube and Sutherland, and the Advocate General has also recognized this in his opinion, that this is seemingly the only way to make sure that Article 17.4 can work. Strangely, however, of course, the Court of Justice in numerous instances has ruled that the installation of general filtering and monitoring obligations or mechanisms would violate European Union law. And this is also restated in Article 17.8 of the CDSM directive, when we look at the context around Article 17.4. So this is one of the first issues we will have to look at. We also have to look at Article 17.7, which states that users should have the right, there should be a guarantee that certain lawful uses can be exercised. Now, the problem with automated filtering mechanisms is, of course, that they cannot distinguish reasonably between lawful and unlawful users. Automated filtering mechanisms, until today, are context insensitive. So automated filtering will eventually lead to the prevention of lawful users, but this seems to then collide with Article 17, paragraph 7 of the CDSM directive. It will lead to the preemptive filtering of uploads that are protected principle by the right to freedom of expression, and therefore constitute an infringement of the right to freedom of expression. So we already have an internal conflict here between Article 17.4 and Article 17 of the DSM directive. And this, of course, creates a relatively weird, if you want to say, situation for OCSSPs in that they incur a double burden. Joao already said that in Article 17, paragraph 1 and paragraph 2, OCSSPs are required to license content uploaded by their users. This is a burden newly imposed on platforms that fall under the definition of OCSSP. But in addition to that, they have to develop, buy, and use technology that prevents unlawful uploads. They also have to deal with an environment that, at least on the side of limitation exceptions in the European Union, is still largely unharmonized. So what should be filtered in one country might not be necessarily be filtered in another country. And if we escalate it to 27 member states, the intellectual work that OCSSPs have to perform in combination or supported by automated filtering mechanisms is very, very burdensome. Of course, this is mitigated by the requirements of best efforts, but this is also something that still hasn't been properly defined and adds at least to a certain amount of legal uncertainty that OCSSPs are facing. Now, looking a bit deeper into the fundamental rights, try to get to the core of these fundamental rights, or at least try to chisel out the core of these fundamental rights, will be the subject of the next 10 minutes, and then I will hand over to Christophe. But it's important to understand how far we can limit fundamental rights, or how far we maybe shouldn't limit fundamental rights in order to still give full effect to them. And the first fundamental rights, the one that really is at stake, is the right to freedom of expression. And here we can rely on a very, very rich jurisprudence, not only of the Court of Justice, but more importantly of the Court of Human Rights in Strasbourg. And when interpreting the fundamental right to freedom of expression, one should consider that the Court of Human Rights in Strasbourg has consistently ruled, and this is, it couldn't be stressed more, that freedom of expression is one of the most essential foundations of a democratic society, and one of the most basic conditions for its progress and for the development of every man and woman, I want to say. So this is something we should keep in mind, that freedom of expression, although there is no hierarchy within the Order of Fundamental Rights certainly has a very, very specific position within the fundamental rights canon. We can remind ourselves of the words of Dirk Verhoeven, who called Article 10 of the ECHR the European First Amendment. Now, the Court of Human Rights has ruled in a number of cases that ex ante filtering is very, very problematic, at least, and should be avoided. Most importantly, ex ante filtering, so filtering of content before it is being uploaded, should only be allowed in very, very specific situations under a very, very strict legal framework. So there must be very, very precise rules in place in order to allow, if at all, now this is allowed in the open ex ante filtering, but any restriction of freedom of expression require a very, very stable and strict legal framework. You know, the conditions are laid out in Article 10 itself, of course. Okay, but the problem is that preventive filtering in principle is a significant, extreme violation of the right to freedom of expression. Of course, freedom of expression has a number of dimensions. There's the right to inform, but also the right to be informed, which has to be taken into consideration. So not only uploaders whose content will eventually be blocked ex ante are violated in their right to freedom of expression, but also recipients of information, people who want to access such content, would be limited in their right to receive information. And this dimension can also not be overlooked, and which doesn't really become apparent from the formulation of the polished challenges. The problem here being, of course, again, it's important to stress this, upload filters, filters that recognize similarities in content uploaded, are not able to distinguish based on semantic differentiations. They cannot distinguish context. And just as an example, the reproduction of one image in one context might be copyright infringement. In another context, it might constitute a parody, a pastiche, or something else that would fall under a copyright exception and would certainly be protected by the right to freedom of expression. But we don't have the technology yet that can replace human lawyers. Automated technology will eventually create false positives and therefore block content that should not be blocked, or filter content that should not be filtered. Again, this is what the Advocate General in the YouTube case quite recently has stressed. Lawful content will eventually be blocked. Now, moving on from freedom of expression to the right to conduct a business. As much as the rights of users will be limited, the rights of platforms will also be limited. Article 17 itself determines how platforms have to go about their business. They dictate to a certain extent what type of measures will have to be used by all CSSPs. And it is also quite obvious that these measures are either directly or indirectly connected to substantial investments that OCSSPs will have to make in order to develop or purchase technology that will enable them to fulfill the obligations arising under Article 17. Of course, there's also the dimension that not only will they be required to invest in filtering technology, development or purchasing, but they will also have to make sure that there are appropriate dispute settlement mechanisms in place. There is the opportunity or the possibility of human review, which of course also requires them to employ personnel, requires them to spend the money in a specific way, and they cannot exercise their economic preferences in an unfettered way. In principle, this is not a problem, that companies are being asked to behave in a certain way, but the scale of the intervention here is of course something that has to be considered, and specifically for smaller platforms, for platforms that maybe address a niche audience, this might become fundamentally problematic. And as I mentioned before, the fact that we still don't have a fully harmonized copyright law will also require European-wide operating platforms to have regard to a multitude of legal contexts that would have to be applied to one operational platform. So this increases the complexity of the issue, increases the information and transaction costs incurred by OCSSPs. The right to a fair trial is also something that we have to take very, very serious in this context. The right to a fair trial, as laid down in Article 47 of the EU Charter, states that the limitation, or if a limitation or violation of fundamental rights or any right occurs, an individual should have the right to an effective remedy before a tribunal. And the question is, of course, can we initially consider private dispute settlement mechanisms on platforms as a tribunal? Probably not. And of course, this isn't an absolute provision here. But certainly downstream, after an internalized dispute settlement mechanisms, users should have the right to a review by a court. And in our opinion, it should be a relatively quick review, especially when we talk about time-sensitive content. How platforms should safeguard this is still something that at least we are very much unclear about. So the fact that platforms will be the first line of defense for users in order to challenge unlawful takedowns or filtering of their content is problematic. At some point in time, a court of law has to step in, but this should be clearly integrated into the structure of Article 17. And at this point, this is still relatively vague. So in order to ensure the rights of users, the user rights that are encapsulated in the copyright acquis, but also expressed in Article 17.7 of the CDSM directive, is something that has to be taken much more seriously than is currently being done in order to safeguard the right to a fair trial. And of course, this is also a European problem because Article 17.9 is so vague, and it will most likely then create, and I think Martin will give us a bit more of an insight into that, different dispute settlement mechanisms or different dispute settlement structures in the various member states depending on the implementation of the directive. Very, very briefly, two more rights, and then I'll hand over to Christophe. The right to privacy is, of course, also affected because filtering will automatically and eventually result in the storing, processing of information. How this will happen is something we should have a very, very close eye on. In ProMusica, the Court of Justice has also set relatively tight limits on the way information of private users for the purpose of copyright enforcement has to be considered under EU law. So this is also something we should keep in mind. And of course, the right to property, we should not forget that enforcement has to be efficient, but the enforcement of copyright and related rights on the internet must be respectful of the fundamental rights of users and platform. And historically, we have seen that the Court of Justice, even before copyright harmonization, has been willing to limit the right to property, for example, by establishing the exhaustion doctrine at European level. It has set strict limits in ProMusica, took a step back in Basta Lübbe later on, to the notion that property has to be a right that is absolutely protected. So this is a myth that we often find in literature. So even the right to property can be limited in this sense. So property is not the most important right. And if we see there are four fundamental rights opposing the right to property, the balance in the mechanism of Article 17 of the DSM directive seem to be slightly skewed. And after this tour de force through European fundamental rights, I hand over to Christophe to discuss the guidance, the opinion, but also to give you an outlook of what might be coming in the future.
Okay, thank you, Justin. After discussing here the fundamental rights implication, let's go a little bit into what the Commission had said about 17 and how it should be implemented. It is interesting to Joao has very rightly reminded us that the guidance came very late, actually too late to make really to be decisive, because it was published like the week before the deadline for implementation was passing. So we see here that there has been a strong hesitation, and that is extremely sensitive for the Commission to come up with some sort of a interpretation guideline that is mindful of all the interests. But what is clear is that basically the Commission in the guidance admits that automated blocking would lead to false positive, meaning that the filtering is not representing a legal assessment or a legitimacy of the upload. So what the Commission proposes here is that automated blocking is in principle limited to manifestly infringing uploads. Joao has reminded us with additional criteria, which you don't find in the directive, and that came a bit as a surprise, even though some of the ideas here are not necessarily to be rejected, is the fact that content that is earmarked by right holders should always be blocked. And what is this content? Content that is particularly time sensitive, like pre-release music, the latest James Bond before it's in the cinema, etc., etc. I'm trying to switch the slide. All right, and then so we understood a little bit more what could be filtered and what could be not. Although, of course, it is not very clear until today what manifestly illegal upload is, and we'll surely have to discuss the future. The opinion of the Advocate General came also late, so it seemed to be that it was kind of delaying its position on this. And finally, 15 July, the Advocate General basically recognized that automatic content recognition tool, in order to filter content of users, are also inevitable in order to basically fulfill the obligations Article 17, and this leads to an interference in the exercise of users' freedom of communication. So even though he at the end comes up with the idea that Article 17 provides sufficient safeguards and it's a proportionate limitation of the right to freedom of the exception, he stresses the fact, so it's certainly a call for caution, that there is an interference with freedom of expression, and then we have to look on how to make this interference acceptable, proportional, and then he is trying to propose some criteria. And it is interesting to see that the criteria that he proposed seems a little bit similar to what the guidance is proposing, but it's a bit more precise. So he thinks that in order to prevent overblocking, an intermediary may only be required to filter and block information which has first been established by a court as being illegal. This is, I think, makes absolutely a lot of sense. Or otherwise, information, the unlawfulness of which is obvious from the outset, that is to say, manifest without the need of contextualization. Here, it's much more specific than the guidance, and it seems to me that in order to fill in this criteria, there are not so many obvious contexts or content that can be filtered, because what is obvious from the outset without contextualization is very difficult to establish, I think. There are many examples where, for example, an entire work has been reproduced for information purposes. This was, for example, the case in the famous Funke decision, where an entire military report has been published. So there is always a context in which you upload the work, and the fact that it's one-to-one copy would not meet this criteria. So it's much more specific, and it also needs to always look at the specific situation of the upload. So trying to switch the slide, but it does not work. Here. So overall, let me just check. Well, it does not react anymore. I have to switch slides. Justin, can you help maybe?
The slides are switching. I think there's an input on your end. The slides are moving. You're now on first slide of the guidance. You see it again?
Okay. Yes. Okay. So on the issue of general monitoring, we know, for example, that Article 17 prevents general monitoring. The Advocate General says that it does not preclude all types of monitoring. So he is more specific here, and he says that if you are targeting only manifestly illegal content, you perform targeted monitoring, and this should be allowed in the context of Article 17, and he refers himself to a decision of justice in the Glavničnik case, where this has been already admitted. Here, what is interesting is that the Advocate General seems to say, okay, it is generally compatible with the Charter, but you need to implement some safeguards of the rights of users, some practical safeguards, and the member states, when they implement the directive, and the Commission needs to check that these safeguards are really in place and well functioning. And what the Advocate General also specifies is that this can clearly not be left either to right holders or to the internet service provider. It cannot be something that, like, you deal among yourself. This is very important, and because of the high standard of freedom of expression, it needs to be a transparent process. It needs to be under the supervision of a public authority. So this, I think, is an extremely important message to all the member states and also to the Commission, in order after to check if the member states have implemented correctly. There needs to be very strong safeguards and these safeguards need to be controlled by public authorities. So here, the conclusion of the Advocate General is that there are essential, therefore, if you implement, we have a proportionate of the right of freedom of expression. So Article 17 is lawful, but carefully with significant constraints. So conclusion that from these different, from the challenge, from the guidance, from the YouTube and Siando decision, and from the Advocate General. Well, first, according to the Advocate General, Article 17, compatibility with freedom of expression, I would say, is extremely fragile. And it entirely conditional and on the safeguards they will provide against overblocking of legitimacy. Here, of course, we see that a mere copy-paste of Article 17 is not sufficient in order to meet this criteria for the Advocate General. And so when we look at the current implementation process, there are several of the implementation laws that are not meeting this criteria. And so I think the Court of Justice will probably have to also go a little bit further and require either concrete measures or at least take stock or take a note that so far the legitimate concerns by the Advocate General have not been addressed by the legislators. It is also unclear how these processes will be done. The safeguards will be implemented. Even the manifestly illegal criteria needs to be, I think, and we defend this in one of our paper, needs to be read in a freedom of expression compliant manner. And this is not really clear what this means after all. Again, Article 17 also is not providing legal certainty. Justin has reminded that exceptional limitations are not harmonized in 27 member states. So basically, it's very difficult to know what is allowed and what is not. Article 17 also violates other fundamental rights that are not challenged by Poland, but have a direct impact on the exercise of freedom of expression. So our conclusion here is that there is still room for annulment of Article 17, given these uncertainties, and this would give the European legislator an opportunity to elaborate a balanced liability regime for platforms. We know Article 17 has been extremely contested. It is still very difficult to implement. We will probably have various scenarios in different member states, which will be extremely difficult for users, for platforms, for everyone to understand. And we would have the opportunity to look this through again in the Digital Service Act. It's not going this direction right now, but who knows, the Court of Justice, if it takes a courageous decision, might bring this again to the agenda. But even without the Digital Service Act, when you read the guidance, the Court of Justice judgments in YouTube and Siando, and the opinion of the Advocate General, you have a better, a more flexible and a balanced framework for content moderation. And maybe you actually don't even need Article 17 anymore, because you can refer to a quite sophisticated body of understanding for Article 17. And then there is something a little bit more thought. We're in order to implement fundamental rights and to secure that a coherent interpretation, a fundamental rights compliant interpretation is given in all member states in a similar way. We would need, and this is based on freedom of expression, but also fair trial that was reminded us earlier by Justin, we need an independent EU institution to monitor the process of the implementation of platform liability. What could this EU institution do? It could determine the stay-down standards. We have seen that the criteria of manifestly illegal content is not clear. It's very complex assessment. Should not be left to private actor, what can be online and what not. There are some interesting thoughts. Actually, I must say that what the Commission came up with time-sensitive content could be one of the situation where you declare this as manifestly illegal, but it's written nowhere. So who should determine this? And here I think a new independent institution would have the legitimacy to do so, maybe also to conduct some studies in order to see what are the content which are basically needs to be blocked up front and where there is really harm. This institution could also take jurisdiction over takedown and stay-down disputes. in the sense of an alternative dispute resolution mechanism, which is, according to a latest study of WIPO, strongly encouraged. Maybe as a court could do the appeal. All this needs to be determined, of course, but there is room here for independent assessment. Also because we have stressed in some of our papers that the human review is sometimes something that we should watch with caution, because who is this human that masters 27 copyright laws in Europe, speaks many languages, and knows exactly when a parody is there up front in 10 minutes and can decide about it. So we need here independent mechanism to check the content. It could also, this institution, develop binding best practices, moderate the stakeholder dialogue in a maybe more efficient way than the Commission does it, because it can also at some point maybe interfere and say, well, we have discussed now for 2 years, let's come up with some solution. It can provide for empirical studies. There is a strong move for evidence-based IP legislation. We need to transfer this into practice, and I think here the fact that the solution will be backed by economists or by even social studies, I think this would make the solutions more acceptable in the future, and content moderation is becoming such an important fact in the EU that we need some data. And also maybe this institution could gather academics, functions as a think tank, and propose improvement to Article 17 or to the directive in general. And that brings me to maybe an idea that is a sort of a dream, is that in the future we might have an independent regulation authority like we have often in competition law, such as the EU Copyright Council, that would not be restricted only to the fact that we need oversight over content moderation, but more generally to secure a fair balance of interest in copyright law. We have problems of legitimacy of the system because authors do not participate sufficiently to the copyright game. And this is something that me and some of my PhD students have worked on and tried to conceptualize the building of an independent regulation authority, a EU Copyright Council, that would have the role to come up with better policies that we have seen in the future, and particularly to look forward with is a thesis in that will be defended early 2022, the design of institutional approach for copyright reform. And I think we are through our presentation now. I hope we have given you some insights on possible scenarios after the challenge. There is still room for improvement, certainly in court or legislator or via regulation measures in the future. On behalf of Justin and myself, we thank you for your attention, and we look forward to the discussion and the next presentation by Martin.
Thank you very much, Professor Geiger and Justin. That was very inspiring. We have already started a discussion at the back of the room with Ula Furgał on the proposal on the independent institution. So it's already all the proposals are already alive and being discussed on the floor, you could say. So very stimulating. Thanks a lot. we will now have Martin, who is with us. Yeah, I can see Martin. So I'll give the floor to Martin right now. I think your microphone is turned off. We still can't hear you. The mic is off, I think, Martin.
Martin, if you scroll your mouse to the bottom of the screen, there should be a mic's icon there. It's.
Oh.
No.
I think yeah.
You
do
could
have a
check the
problem.
input source on the little settings wheel, if that might be an issue.
Check on the settings wheel as the input source, just sometimes.
You know?
We can
Yeah.
hear you now.
Good.
Excellent, excellent. You're with us.
Okay.
Great.
Yeah, I'm not sure what the problem is.
So the
because-
floor is yours.
Yeah, thank you so much. I'm sorry for this. I'm not sure why that is, because the icon was green. And in any case, I hope the connection bears with me. It's been a little bit patchy over the last half an hour, so I hope that it's gonna work. So first of all, thank you so much for having me. Rafał, Professor Sikorski, thanks a lot for inviting me. I'm really glad to be part of this panel. I'm particularly looking forward to the discussion. So I'll try to keep it short. And you know, my job is made easy by the fact that I had my esteemed colleagues, Joao, Justin, and Christophe, who basically explained everything important that was to be said. So I'm here only to limit myself to some supplementary remarks in my intervention, which I try to keep short. So first of all, what I try to do, I don't have any slides, but what I try to do is I try to split the presentation into 3 different sections and a conclusion. So first of all, I'd like to talk about a scope. Christophe and Justin, and I assume also Joao, because I wasn't here before, covered the debate about what are the preventive duties under Article 17. And I think most of the conversation these days is about that. It's about what is the scope of preventive duties that are implied in Article 17. Which means that we are not really discussing, for instance, the scope of licensing obligations and whether they are perhaps having some fundamental rights issues, as some authors, like Professor Spindler, were, for instance, arguing in the literature. We're only discussing the filtering part. I think for a good reason, but I just want to sort of highlight this because member states can do all sorts of things and it might not always end up well. Okay, so we're discussing the scope of preventive duties. And I think you have heard from Christophe the conversation that the Advocate General and the Commission and academics have about what actually Article 17 requires. The law is very vague. So we don't know what kind of thresholds or what kind of limits there should be on technology. But we all understand that those limits are important to prevent that there is overuse of technology in the areas where technology is not up to the task. Now, what is interesting for me is now not the question of the threshold, because I think this was covered, but it's the question of who should actually determine the threshold. Advocate General O, and I think this is quite crucial for his opinion, says that it is for the member states and the Commission to determine the detailed rules when it comes to the threshold and the scope of the preventive duties. Now, first of all, I take the issue with the Commission. I don't think it's up to the Commission to do this. I welcome that the Commission is thinking about this in its guidance, but I don't think it has any mandate to do this. There's nothing in Article 17 saying that a Commission can specify, it cannot issue binding acts. It's all up to either the member states or the EU legislation as interpreted by the Court of Justice, but there's no room for the Commission to set up those thresholds. So in light of the recent case law about validity of soft law instruments, I think it's quite clear that if they try to go too far, someone could easily attack these guidances as just overstepping the mark. So that's my first issue. I don't think it's up to the Commission really. Commission can brainstorm, but that's all it can do. Second, it's clear that it's then up to the member states because the Commission, because the EU legislation is so vague on this point. Unfortunately, it is a good principle to state this, but in reality, okay, so the principle that, as stated by the Advocate General, let me maybe rephrase this, is that member states should do this. Member states should incorporate content recognition tools, which help to distinguish what seems manifest and what is ambiguous, because this should be done in the national legislation. Now, I agree with that. The problem is, the reality is that most of the member states are saying, we don't care. We are not going to set up these parameters in the national legislation. So we have one legislature that decided to do this, even before the opinion was out. But for most of the legislatures in the member states, they are just not doing anything. They're just doing copy and paste. So principle is good, but it's just entirely disobeyed by the member states. So is that a good enough outcome? Let's see. Let's discuss this at the end. Second, on procedural safeguards, because obviously one thing is to narrow the scope of preventive duties, but a second is to introduce safeguards to prevent abuses even within the situations that are regulated by these preventive duties. And here, Advocate General is really thoughtful on many different safeguards there are. Effective complaint and redress mechanism, alternative dispute resolution, particularly judicial recourse. Now, Advocate General says that those safeguards are useful, but he also says that guards are on their own sufficient to create fair balance, meaning that safeguards are part of the story entirely. Let's look at the reality. The reality is that most of the member states are not really capable of delivering any effective safeguards. Because if you copy and paste a provision saying something should not happen, and you copy and paste provision saying a provider should have effective redress mechanism, without actually then introducing some mechanism to supervise this, and perhaps sanction when providers don't do this, then there's just no effective remedy, because you just have it on paper and it doesn't really do a thing for the users. And unfortunately, this is what is happening in most of the member states. They do anchor the principle that you have a complaint right. They do anchor the principle that it should be effective and speedy and everything, but they don't do anything in terms of the supervision, transparency, and sanctions to actually make sure that that happens. So it's like saying you have a right to equal pay without saying that there are any instruments to enforce that claim and that obligation. So I think that's deeply problematic, and it just shows that it is nice to have the safeguards, but they cannot be only copy and paste of a provision, as Christophe said. Copy and pasting Article 17 just doesn't do the job. And it won't be compliant with the constitutions and EU Charter. Now, a similar thing is happening with alternative dispute resolution, right? So the Article 17 only alludes to this, and it leaves all the details to the member states. And basically, most of the member states, the only thing they do, they say, oh, and you can agree on arbitration and a mediation. How is that helping anyone, right? They could always agree, even prior to this directive. It's nothing. There's no added value in that kind of provision. Judicial recourse, some member states might anchor this specifically in their implementations. Some of them don't, saying, well, it's kind of imminent in the law. Again, they're not helping anyone to be able to enforce this, again, with the exception of some member states where you have some collective redress mechanism for these sort of things. And transparency is entirely missing because, of course, the directive itself doesn't require much of it, so member state legislatures are not really rushing to do much there. Which brings me to my overall point about supervision. I think Advocate General proposes that all of these procedural safeguards should be implemented by the member states. And then the scope should be also specified by the member states in light of the problem with overblocking. And that there should be supervision on all of these aspects on the national level. In fact, he says Article 17 obliges those providers and also the administrative and judicial authorities of the member states when supervising the implementation of that article to consider the collateral effect of filtering measures they implement. Now, in many member states, there's no such thing. There's no supervision. Unless you say that the only supervision is that maybe some user sometime in the distant future will sue. That's the only supervision that you get. There's no administrative oversight. And in most countries, we don't even try to create collective redress. We don't try to create some sort of oversight from the ministries when it comes to the handling of the complaints of users, or even try to arrive at whether there is any rate of overblocking. So again, it sounds nice, but it's just not there. Which brings me to my main point and a conclusion about this. I think Advocate General's opinion is very thoughtful and it really goes to the right direction. The problem I have with it is that it assumes, even though it states as a principle, that EU legislature dragged the member states to the situation where they have to introduce this very serious interference with the freedom of expression. And it's responsibility of the EU legislature to introduce safeguards on the EU level. It at the same time also says that much of the job has to be done by the member states. In fact, if you read the opinion, you get the message that EU legislature did something, but not enough to make this survive on the national level, even from the perspective of the Charter. And I think the serious question we should ask ourselves is that if we end up with the situation, if the court would follow the Advocate General's opinion, I think the result is as follows. Result will be member states implement this legislation, and then on the national level, you will have constitutional complaints about insufficient implementation in these member states. As the law stands in member states that implement it, basically most of the member states have an issue there when it comes to procedural safeguards and supervision at the very least. Which means that those constitutional courts, perhaps in a dialogue with the Court of Justice, would conclude that the national legislatures didn't do enough to remedy and to safeguard against abuses. But the strange effect of this is that none of the blame would come back to the European legislature. European legislature, if of course Advocate General is followed, would be seen as doing a sufficient job to pass a legislation that is constitutionally compliant. But the member states have most of the work to work out, and they would be seen as constantly underperforming. And in that situation, if this is happening in many member states, you keep asking, why isn't it that the EU legislature should have done a better job? And did the EU legislature really do a sufficient job in this case? And this is where I'm skeptical, because particularly when it comes to supervision and when it comes to transparency and supervision of the safeguards there are in the directive, there's just nothing specific in the directive. And same goes for the scope and supervision of the scope of preventive duties. Now, is it acceptable that EU legislation does that and just implicitly passes the ball to the member states, and they have to figure out in the conversation with their national constitutional courts what the problem is? And we accept that EU legislation can be designed in this way. I think that's for us to answer. I think that we should really expect a lot from the EU legislature, because otherwise we have some systemic risks for the future legislation. So I think, while I'm very sympathetic to the proposal of Advocate General, I think structurally the problem I see is that Advocate General places a lot of responsibility on the member states and little responsibility or limited responsibility on the EU legislature. And I think there should be more responsibility, not all, but more responsibility on the EU legislature to draft safeguards and to draft the appropriate scope. And I think this is where the legislation is flawed. So I don't disagree on merits in terms of whether what he proposes as a potential reading of Article 17, it would be constitutionally acceptable. I don't have qualms with that. I'm totally supportive of that. I always said that some form of Article 17 would be constitutionally acceptable as far as I stand, from where I stand. But in the form as it's designed at the moment, with the safeguards that it has and hasn't, I think that we have a problem. So I think it's actually a deep constitutional question, because it will influence how the EU legislature has to do its job in the coming years. And so far, Court of Justice is rather famous for not properly disciplining the EU legislature, with the only exception being area of fundamental rights to data protection and privacy, where court has done some work. And actually, this area offers an analogous situation to this one, which is though a little bit more easy to understand, because it is a sort of vertical situation where data retention was scrutinized before the member states and their constitutional courts for many years, until after many years it finally arrived in Luxembourg, and Luxembourg said, well, actually the whole directive is invalid. So I think here we have inverse of that scenario. We have a first Court of Justice looking at the validity of the directive, and then member states constitutional courts figuring out whether the member state legislature did enough. And I think it's useful to some extent, but I think it offers some risks, particularly that a Court of Justice says too early that it was enough what the EU legislature did, because I don't think it is enough. Okay, and with this I end, and I'm looking forward to the discussion.
Thank you, Martin, for this interesting presentation and interesting, inspiring, intriguing, and provoking thoughts. Thank you very much. We do have some questions coming from, I think Martin is speaking, but I can't hear him. Okay. So we do have a few questions coming from the audience, some of them very fundamental. I will put them basically all for the discussion. By sometimes particular speakers are mentioned, sometimes it's more general questions. So I will leave it to you as to how we address them. There's a question for Justin, one of our attendants, internet attendants, is saying that regarding the right to fair trial, can it be argued that it is not at risk simply because uploaders always have recourse to traditional courts? Of course, the directive does mention traditional courts. What trust do we place in the ability of having those disputes decided in the traditional courts? That would also be something very interesting, because we would have people go and try to enforce their user rights in their national courts. We know that users have not always been successful with various user rights based on various exemptions and limitations in doing this. So I think that in this case, there's an interesting message in Article 17 that the courts should be able to enforce that. So that's one question for Justin. For Justin, the other is a more general thing. One of our participants is observing that okay, so much has been said about the harmonization being a failure here, and that Article 17 leaves so many things undecided, or leaves so many things to the member states that it's hardly clear, transparent obligations. And many of you have also said that the EU legislature should have done better, which I agree. But the question is whether then we should agree that directive is not the right instrument and that we should proceed with a regulation here. That's the question coming from one of the participants. And then there is also a question on the new authority. One of the participants is saying that would frustrate the purpose and the meaning of the directive, and it would transfer power from the legislature and courts to the executive authority, which, as one of our participants says, is from a broader perspective also problematic. So I think the questions goes to the proposal by Professor Geiger and Justin on the EU institution that would monitor that would monitor how various freedoms are included in this balancing between platforms and users and the right holders. Okay, so that's so much for the questions as for now. But you can also feel free to have other comments related to the discussions, to the presentations that we've had.
I'm happy to go first, but Christophe was raising his hand, so maybe he wants to say something first.
Please, sure.
No, maybe just because I would like to react to the excellent presentation Martin just did and add maybe one element with regard to the challenge. There's one argument that the court could pick up if it shares the opinion of Martin that the legislator had done quite a lousy job. It's an argument that was raised by Bernd actually with regard to the 2001 directive and picked up later on in a very good PhD thesis by Anna Ramalho. The Court of Justice has the ex officio possibility to say that this directive does not harmonize. And in fact, it does not really harmonize. You see the implementation in Germany, in France, or in Spain is so radically different, for example, in Article 17, but also in other areas, that you can see that even with the guidance, there is no harmonization. When there is no harmonization, there is no competence, because the competence is in Article 114 of the Treaty of the Functioning of the European Union. The legislator needs to come up with solutions that are harmonizing the internal market. Now, when you add some arguments here that are linked to Schrems II decisions about legal security and foreseeability of fundamental rights restriction in the EU, the Court of Justice could also strike down the directive on this ground. I don't think it will have the courage to do so, but it could be done, and it does not need to be in the Poland challenge, because the court can do this ex officio. This is a quite powerful tool if the Court of Justice wants to do the job that Martin invites her to do. And with regard to the supervision authority, I'm happy to answer, but I leave the floor first to Justin because the questions were first addressed on fair trial and other matters.
Okay, I quickly answer on fair trial and then about spec, because I think the latter two questions are fairly horizontal, and I think they enable us all to answer. Right to fair trial, I absolutely agree. I mean, of course, there is the prerogative always to go to an ordinary court, but the right to a fair trial also has an efficiency dimension. Right? It has to be a recourse that is efficient and also quick. And of course, we have to distinguish two things here. When platforms adjudicate on disputes between users and right holders, this is a private court, if you will. It's a private tribunal, it's a private dispute settlement mechanism, and there are legitimacy issues. They can be quick, they probably are more efficient in dimension than the ordinary courts. But then getting to the ordinary court, specifically when there's a first instance, if you will, at the platform level, then filing a suit before the national courts, that can take ages. It might not be quick enough, so there might be a right to have recourse to the ordinary courts, but it will not serve its purpose to get content that will be topical, that will be timely, reinstated as quickly as possible. So the effect will be, and this is what procedural element, in my opinion, cannot be separated from the substantive element. The effect will be that lawful content will at some point be reinstated, but not with the speed that it will be necessary to take to give effect to the right to freedom of expression. If a written document is being republished, then after even 6 or 7 weeks, but most likely 1 or 2 years, that's not enough to safeguard the right to freedom of expression. Fully support Christophe's point on the competence. It might make sense to have regulations there. But certainly, I think Martin is also correct to say that the European legislator should have been a bit more precise in determining, coming back to the term Sutherland, how Article 17 will affect the operation of all CSXPs, but also will affect the way in which we exercise our fundamental rights online. I also don't see much of a problem in distributing or delegating some of the tasks to an executive authority, because as long as there is a proper legal basis, and certainly not unprecedented at the European level, to delegate authority, sovereign tasks to an agency, some other authority, this is perfectly fine. But again, there we need a proper legal basis that is precise enough, that describes the tasks, and that tells the any authority whatsoever, whichever form it might take, what to do and how to discharge of the task. It's simply a question of how do we frame the delegation of powers from the legislature to an authority. Because the other option is we delegate these powers to private operators. And then I ask relatively provocatively, what is better? Do we have an authority that you can criticize for being illegitimate? Or you say we delegate tasks that significantly infringe potentially rights of expression and fair trial rights to private platforms who have their own motivations. And I think these are the fundamental questions we have to ask, aside from the question how can we restructure an online content sharing service provider's liability system, difficult expression in the future. That's from my side.
Yeah,
Okay,
so
if I just may add one aspect on the regulation authority we propose, it's like the alternative dispute settlement mechanism is just one of the different tasks. I mean, it is much more. It's a much wider construct that we will propose here, and I think it should also, and in the light of what just Martin said, and earlier Joao as well, it is that we know that this system that we have now is certainly not perfect, and we need to come up with a solution to make it work in the future. Even all the criteria, it has been said, are vague, so they need to be interpreted. So who interprets it? Member states in a diverging way, probably, because everyone would have a different understanding of manifestly illegal, and then we have to wait that the Court of Justice in 5 years or more specifies what it means. Or we have some sort of a legitimate body that can reflect on this and come up with guidelines, proposals, informed decision making. Maybe see also with technician, computer scientists, what is doable in the future, etc., etc. We need to have everyone on board on this, because basically this is a real hot society issue. What we can do on platforms is the main question of our, I think, on democratic participation on online. In regard to the dispute resolution, of course, this has to be thought through. There is no I think there is no hindrance to maybe build in some court review of decisions and at appeal, for example, appeal stage. I don't know, maybe involve the Court of Justice at some point. This needs to be elaborated, of course, and needs a little bit more thinking. But if we want to involve courts, this can be done within this system as well.
yeah, maybe I can just jump in with 2 additional comments. One is that depending, in line with what Justin, well, actually with what all of you were saying, but the assignment of tasks to such an authority, we have to be aware of how we divide this up, because in terms of substantive decisions, for example, what we have now in the intelligent transposition, there's a specific role for the IJCOM there. But if you're asking this authority to play the role of intermediate court, it has to be a national authority because a lot of the substantive decisions are about assessments under national law, right? So if you want to have a European authority, then that reality of what they can decide upon has to be different, more procedural, I would say, in nature. Obviously, eventually, this will be an autonomous concept of EU law, go to the Court of Justice, but I think from a practical perspective, this is what we need. I think the risk of what we have now, maybe it hasn't been mentioned yet, so it's worth putting out in the discussion, is that this is a legal regime that is targeted at a very few number of platforms in its design, in its intention. And what is happening now is that if you have copy-paste transpositions in most national laws, these platforms are going to legitimately choose the type of transposition that is perhaps most detailed, and I would say the German one so far. And if they decide that this transposition that is compliant with the EU law and the requirements of Article 17, the logic would be that they roll that out through all European member states in their services in one form or another, and until they are forced to not do so for part of their services by one national member state. That means that the flavor of safeguards and acceptable speech, to call it that, online on these platforms will be de facto decided by a choice based on one legal regime. And we should be aware of this because that is the cost of a lazy or very cautious approach by a national legislator. There are trade-offs here, and this is a trade-off that should not be ignored.
Yeah, so I would just add, I mean, those were excellent points. I would just add that on Joao's last point, I think yes, that could happen, though you would probably very quickly have a pushback because if Spanish transposition says that you have to pay regardless, then I'm sure that there will be litigation if some other countries try to use a different language for either the scope or the kind of the size of the effort. Then again, you probably have a litigation there. I'm not sure whether the platforms, given that they have to factor in the risk, would necessarily then go with the most elaborate transposition. So I don't know. Actually, I honestly actually don't know how they, because I don't know how I would even square the circle, right? But on some of the points, yes. So I agree. It could happen that the German transposition rules, and for instance, influences how, say, YouTube will set up its automated tool. I think already the clear improvement is that now, I mean, up until now, we were mostly right holders who were setting the parameters of the content ID. Now, if you decide not to ignore German transposition, actually you should limit their choice in terms of how they can set the parameters, and you need to drive the automation a little bit more than before. So that would be obviously interesting outcome, though. The problem is that a German transposition is a full package. So, for instance, Slovak citizens who have to live with probably a very copy and paste transposition will not get collective redress as you get in Germany. So, you know, what do we do there? Do we go to Germany to sue in case we have a case like this? So, I mean, clearly, it points to what Christophe said, that this is a very unusual situation where we have a piece of legislation that creates more mess than perhaps one would expect from harmonizing legislation. Now, is it enough to say that as a result it violates competence clause? Well, just kind of thinking about incentives of judges, they're very unlikely to police this boundary in a very strict way. I mean, they're known to be super lax with the proportionality, subsidiarity, all of these requirements when it comes to the competence. So while I can see that, maybe it might happen in the coming years since there's more and more criticism vis-a-vis how the court polices some of these things. At the moment, I'm skeptical that they would actually look at the competence and use that basis, which is why I think fundamental rights could be a different angle at a very similar consideration, because there the consideration is that EU legislature is increasingly at the job of introducing sometimes very draconic measures. And then the legitimate question is whether the legislature itself is implementing safeguards in terms of scope or procedural, or whether it's just rolling everything to the member states. Because that, I mean, has one implication in terms of politics. If you don't have to have safeguards in the EU legislation, then you don't have to discuss it in the parliament. Then you can always say, oh, the member states will do the job. So I think from the perspective of fundamental rights, it's probably more likely that a court would take up the task than from the perspective of the competence. But I see your point, and I think the court should think about that area as well, because this is a good example. Now, to the question from the audience, is this a problem of the directive? I don't think so. I don't think this is a problem of the vehicle. I think it's a problem of solution and how it's drafted. I think if we had the same language in a regulation, little would have changed. So I think the real problem here was that there was just incomplete agreement among the stakeholders, and they just pushed through something that was just very highly undefined, incomplete, and now we're living with that. Now, of course, now there's some people try to argue that incompleteness should be read as exhaustiveness. But again, that's just sort of ideological argument. I don't think that's the argument based on the law. It's a directive and it's vague, so it can be implemented in all sorts of ways. But it's unfortunate in terms of the outcome. That is clear. So what will exactly happen? I think there's a bias for the court to harmonize this instead of the EU legislature, which again brings the question: is this a good model for the coming years?
I would have one more question, because and that would be directed to Professor Geiger and Justin. You've the Polish challenge is just based on basically based on the freedom of expression. Your analysis that is also available in one of your articles is much more profound from the perspective of various fundamental rights, and it seems to take into account rights from the different stakeholders involved in this process. Now, it seems that the right to conduct business is not very popular today, given the attitude towards platforms and the shift that has happened. But which do you think is the most important of the five, I think, that you've mentioned here, and or are they equally important, or which one would you have most trust in? All of them are very well founded in the previous judgments of the Court of Justice and the previous understandings, the previous interpretations of the fundamental rights. So how do you see the chances of looking at this issue from the perspective of other rights, or other fundamental rights, than just freedom of expression? Because certainly this freedom of expression is a perspective of one of the stakeholders, users, but of course the freedom of to conduct business, it's of equal importance. That's a right that is of very important status in the community, in the union, of course. And I think in this discussion, it tends to be forgotten a bit, and it's only the user's perspective or the intellectual property rights holder's perspective. And a good copyright law today, I mean, in all aspects, has to take into account the interests of the right of all the stakeholders. After all, for the past 20 years, we have greatly benefited from what the economy has achieved through the operation of the platforms and the access to knowledge. The exchange of knowledge, the exchange of culture, etc. So don't you think that this perspective is not played out sufficiently in this discussion? This freedom to conduct business perspective? Or are we afraid to put it, maybe? And we should, because just one of the fundamental rights, one of the fundamental freedoms, just like the others.
Christophe, do you want to, or should I get going?
I would be very grateful if you could rephrase because I don't hear unfortunately, I don't hear well when Professor Sikorski speaks in the microphone, so I didn't really hear the question.
The question, okay. Can you hear? Is it better now? Can we fix that problem here?
It's not very good, but maybe
I can rephrase it.
Yeah.
Yeah, I can rephrase it. So it was a long question. I tried to summarize it, but it's a good question though. So the Polish government only based its claim on the right to freedom of expression, but there are also other fundamental rights that we highlight in our paper. Is there one that is probably in a better position? That's how I understand the question. To be more successful and challenging, or how should we also consider the other fundamental rights? Specifically the right to freedom of conduct business, because at least as Professor Sikorski argues, I might have an issue with that, at least sensitively, that platforms themselves have contributed to, call it cultural well-being, to development of an online cultural exchange significantly. So maybe we should take the right to freedom of conduct business, but also potentially the right to property a bit more serious. But as you know, the question refers to the right to freedom of expression. What are the other options then? I leave it to you. I have a couple of thoughts then afterwards to add.
Okay, so if I may, so it is true, and we highlighted it in our presentation that the Poland challenge is based only on freedom of expression, but we consider that many other fundamental rights play a role when assessing freedom of expression. For example, if you take for the activities of how citizens express themselves, get their information, and do democratic participation at large, it is mainly through platforms. And so if you regulate platforms and put liability on platforms, then of course freedom of to conduct a business is a derivative, or at least is also targeted as a restriction of freedom of expression. Because if you restrict the possibility of users to, interact on platforms, then you have also an impact on freedom of expression. So it's collateral damage, if you want. Same is true with regard to freedom to fair trial. Fair trial, for example, mandates that there are procedural safeguards, but freedom of expression itself mandates that there are procedural safeguards to restrict expression. And this derivates very clearly from the case law of the European Court on Human Rights. So basically, you cannot really isolate freedom of expression from all the others. Basically, they're all interrelated. And when it comes to property, of course, the fact that we have this discussion and that there is an Article 17 and that there should be some sort of a regulation of content moderation is the image, or is the consequence of a problem, and no one denies this problem, that there should be some sort of a moderation here. It is denied by, I haven't heard any scholar doing so, but the fact is, how far should it go? How much should it restrict other fundamental values? How much should it impact also on the functioning of online speech? I think, or even regulate what is now framed under the heading of digital constitutionalism. I think here we need to be very cautious because we cannot have property suppressing other fundamental values in the EU.
Yeah, I mean, I couldn't have summarized it better, but that always come up when we give presentation in this context. The question number one is, why Poland and why limitation of freedom of expression? So there is, of course, an issue that Poland is betting on one horse. In my opinion, it's probably the best one to bet on, freedom of expression. But as Christophe said, expression is fundamentally linked to other rights. We cannot see them in isolation. We cannot choose either or. They all are relevant in this context. And this is something that I was missing in the discussions before the Court of Justice, so during the hearing, but also in the opinion of the Advocate General. They could have mentioned fundamental rights, and I think the Court of Justice is fully entitled to raise these concerns ex officio. They don't have to wait that one of the parties brings them up. Fundamental rights have to be brought up if they are relevant. So there must be a reason why the court doesn't do it. I still have to find what the reason specifically is. But if I had to choose from these 5 rights, it's probably the right of expression that would carry the most. But with the thought in the back of my head, it's more than freedom of expression, and the other rights are fundamental links as enablers for the right to freedom of expression. Yes, property cannot be annihilated, but property is not a monolith that cannot be touched by other fundamental rights. So this is why I see that there is an army of fundamental rights, or 4 of them, on the one side, property on the other. But even the right to property, we could probably bend into an argument that would support a limitation of Article 17 or a redrafting of Article 17. I still am very, very much uncomfortable with the current outcome and the way it's being implemented. Yeah, Joao is raising hand. This is why I stop now.
Didn't mean to cut you off, Justin. I think to Professor Sikorski's point, the point on freedom to conduct a business is not incredibly strong on the face or on the letter of Article 17 due to, number one, its vagueness, and number two, the fact that 17.5 does introduce proportionality assessment factors that, if properly read, would make it, on the face of the text, complicated to argue that. Now, my view is, ironically, if you were to implement the Commission guidance to a T, you would actually run afoul of freedom to conduct a business, because the combined obligations that the Commission wants to impose, especially on the licensing and best efforts to obtain an authorization side, in addition to some of the requirements, including the rapid ex-ante human review for earmark content, together, this is a complicated argument to make, but together, they impose, I would say, an undue burden on platforms, especially on the licensing side, because when you actually put everything down and understand the consequences, it's almost an obligation to must carry, must pay content that is uploaded to platforms. But obviously, this is not how it's going to be implemented in member states. So I think the argument of freedom to conduct a business per se is not incredibly strong.
Let me kindly and respectfully disagree with Joao, which is very seldom, so I'm happy to do this here. When you take, for example, the decision of the Court of Justice when it comes to filtering, and when we take Sabam, Scarlett, etc., where freedom to conduct a business was one of the main arguments. It was not based on freedom of expression that, in this context. And what does Article 17 actually mandates, if not filtering? So basically, the Court of Justice could, I think, based on its case law, be a bit proactive on this freedom to conduct business, despite all the safeguards they have. Of course, I agree with you in the provision, but these safeguards needs to be made a reality, and I'm not quite sure the guidance or any follow-on thoughts here are sufficient to safeguard this right.
Yeah, thanks, Christophe. I don't fundamentally disagree with you. I think my argument was more, if we could use just freedom to conduct a business per se, as it on itself, on the basis of the letter of the article, I would find it, but maybe it's a legal realist approach, knowing the history of the court, I would find it hard. Sure. But of course we could make the argument.
It was more as a combined argument with others. Yeah, I agree with you, of course. So you see, we all agree after all.
We are unfortunately not disagreeing completely.
Okay, I think we're coming to an end. But before we finish, I have just one more question. if we could bet here what the decision of the Court of Justice would be in the Polish challenge, I think I sense what Martin would say, that the court would follow the opinion of the Advocate General. What would you say? This is just a guessing exercise now, and maybe you could give percentage for one or the other. But what do you think are the chances that we will get another chance at regulating 17 somewhere else with more precision and that we would finally achieve a state where there would not be so much mess as we have right now? We start with Joao.
I'll let Martin start. Go for it, Martin.
80% that he follows AG, that the court follows AG, just because that's the kind of around the general number that AGs follow. 20% that they do something along the lines as I have said, maybe even less. But 100% that there will be many cases coming up after that case.
Okay.
Yeah. So on my side, 100% that this is a great employment program for lawyers. So we're all here to stay for a while. And also 100% that it will in one way or another follow the AG. So I guess a round on me, if although I do not agree with it, I must say I think that would be, I'm very favorable to the arguments that this deserves invalidation. And in particular, I think if one part of the article falls, the whole system is like a very poorly constructed house of cards should fall altogether. So the way I read the current, let's call it political, juridical climate is that there is, I don't see a chance that this won't survive.
Okay. And Professor Geiger?
So I actually hope it will follow the AG because this is probably the most liberal we can get from the Court of Justice. But I would hope also that the Court of Justice sees the weaknesses. Maybe someone is listening to our conversation today at the court, let's be optimistic, or reads the paper that are out there. Because I think the Advocate General, giving the complexity of the situation and the sensitivity, did quite a good job. But we have highlighted some of the deficiency here. The safeguards need to be much more concrete. We need to be, there needs to be follow-up, etc. And I would expect, and I would hope that the Court of Justice says exactly the same, but be a bit more precise on what is to expect from either member states and from the Commission in order to have it validated. Because it cannot be said like, we consider that there are some safeguards, but they have to be implemented by member states. As Martin said, basically this brings back this to the problem to member states. I think personally, I would hope that they also raise the issue a little bit of supervision. This will bring us a little bit closer to what we propose, a regulation authority. And to reply to what Joao says, it's true that it will be regulated at national level, but the potential task of a regulator at EU level would also to be supervising and harmonizing the practices of the different AGCOM and ADOPI and whatever other mechanism that we have at national level. So it's not mutually exclusive. And I think it needs to be done, actually, because if we give power to national authorities, what we will have at the end is even more this harmonized framework. So at some point, you have to have someone who's looking into this. So basically, yeah, let's hope they will follow the AG and concretize the task. I'm, of course, would be very sympathetic of something that goes a little bit further, because there is room for annulment, but having, for example, in mind the trilogy in 2019, when it came to fundamental rights in Funke Media, Pelham, and online. I wonder, I don't think they will go further than this.
And Justin, you're the last to make a projection.
I'm very honored that I'm the last one. The good thing is the court is thinking, because it's taken an awful lot of time to get the final ruling here. So I take this as a good sign that, as Christophe and Joao and Martin also said, hopefully the court will set proper rail guards and really instruct the member states, who might then have to go back to the national implementations and make them a bit more concrete and more fundamental rights compliant. I'm traditionally a pessimist. I don't think it's going to be annulled. But my hope is then that the bit of optimism that still remains is that there will be a strict course. I wish in this instance that the Court of Justice had dissenting opinions, because I think there will be one or two in this context if I look at the jurisprudence of the court so far. But 93% that it will be Article 74 stance.
Okay, thank you very much. Well, definitely, even if the Polish government does not succeed, we've learned a lot from the case, and a lot of fascinating reading in GRUR by many of you, of course, in various places. A great chance for me to get acquainted with all of those discussions. So even if it's not successful, at least the benefit is there. We could share, expand our knowledge, get better understanding of the relationship and the intricacies of the various rights and how they play out together. So certainly a lot that we could have learned, and I hope that at the end of the day we'll get better solutions, more favorable towards all the stakeholders here. Okay. We've reached, I think, the time limit. Thank you very much. If we don't see each other before Christmas, of course, please accept our best wishes. I hope we've already exchanged emails with Professor Geiger, maybe in Copenhagen, a chance to meet live at the ATRIP conference or some other place someday. Hopefully, finally, right now, actually the numbers of cases are growing, so we're slowing down rather than expanding, but I hope it gets better soon, and let's hope for the better. All the best, and thank you very much again for being with us today. Thank you.
Thank you.
Thank you very much.
Thank you.
Bye.
Okay, we will move to the second part right now. It's not a panel, strictly speaking, because we don't have a panel. I think requires panelists, more than one. In this case, we don't have more panelists on the press publishers' rights. Ula Furgał is the only panelist, as it turns out. Ula holds a PhD from European University Institute. She is a lecturer in intellectual property and information law at the University of Glasgow. She also is a member of the Create Center, which is a center for copyright and the creative industries. And there she researches in areas of digital platforms and right of revocation as well. Today, Ula Furgał has published a lot on the publishers' rights and the implementation of Article 15 into national laws. Her most recent, I think, is on SSRN and Oxford Journal of Intellectual Property Law and Practice. It's an interesting text on where we stand, where we're moving with respect to the publishers' rights in various member states. So I'll give the floor to Ula. She'll roughly said she would take around 30 minutes, and then there will be time for questions, which you can post online, or still visit us here at Polish Academy of Sciences. Ula, the floor is yours.
Thank you very much for the kind introduction, and thank you very much for inviting me. It's always nice to be back in my home country of Poland. So as Professor Skibnicki introduced me, I'm going to talk about press publishers' rights in Article 15. And in here, I will just briefly introduce how Article 15 came to be, because I think it's quite important to remember what was the original context of Article 15 and how that relates to the discussions that we are having now. And I will mostly talk about Article 15 in the context of the ongoing implementation. As we heard in a panel previously, and thank you very much for the speakers for the great panel, implementation is not even halfway done. So even though the deadline was in June 2021, not even half of the member states have implemented the copyright directive. Not even half member states have implemented press publishers' rights, because some of them implemented only press publishers' rights actually. So most of the content, most of the CDSM directive is yet to see the national transpositions. So what is the problem that the press publishers' right is actually trying to tackle, or what was the problem that the European Commission said that it's trying to tackle when it proposed the press publishers' rights? So the problem was quite simple. And it was connected simply to one service of one platform, and that was the problem of news aggregators. And here the press publishers were basically saying that their content is being used by Google and they are not being remunerated, and the scope of the right of communication to the public that we had then is uncertain, so they basically cannot license their content. So in here the European institutions back in 2015, 2016 said, okay, we'll do something about that. But already in 2016, the problem that European institutions saw grew. So we started to get a little bit more of a context, and that context was that of not only of licensing, remuneration, and enforcement of copyright, but that was the broader context connected to democratic values, such as the threat to free and pluralistic press and the need to support quality journalism. So we didn't only have this one service anymore. We had this one service in the background, but we also had those democratic values that were coming to the fore. And of course, once the right was introduced, a lot of discussion sprang in here, and we had those very strong two camps for and against press publishers' rights, and those camps are still standing. But the values that we were discussing in here were basically those juxtaposing freedom of users, so freedom to share content online, freedom to receive information, so for the users to have access to the plurality of sources of information online, which opponents of the press publishers' rights were arguing will be threatened once the cost of access of news goes up because of those when those new rights are being introduced. On the other side of the spectrum, we had publishers saying, hey, we need to have it, it's nothing new, this new solution, because you're basically treating us equally with other content producers by giving us this right. Because of that, we'll have this legal certainty and we'll be able to enforce our rights, go to platforms and basically ask for remuneration. And at that point, now I'm saying platforms, but at that point, we're still talking only about Google. So what is the solution that the European Commission proposed? Now we know this is Article 15 of our Directive on Copyright in the Digital Single Market. When it was proposed back in 2016, that was actually Article 11. And this article didn't go through that many changes as Article 17 during the legislative process, but it did go through quite a few changes that considerably, let's say, drastically, too harsh of a word, considerably limited its scope. So what the press publishers' right is basically a neighboring right in press publications that is gifted to publishers of those press publications with respect to online uses of their content by informational society service providers. So this is a right which is not effective erga omnes, but is only effective in the online sphere towards informational society service providers. And we have multiple carve-outs from the scope of this right. So private and non-commercial uses are out, acts of hyperlinkings are out, but also in uses of individual words and very short snippets. And this right is quite limited in time because it lasts only 2 years following from the publication of a press publication. And even though we refer to this right as a right of press publishers, this is actually a right in press publications. So press publications are a central concept of Article 15. And here the directive does provide a definition of a press publication that you can now see on your screen. So basically, a press publication is a collection with an informatory purpose. So we have collections that is composed mainly of those literary works of a journalistic nature. It's issued in a periodical manner under a single title, provides information, but not only about news, but also other topics, and is published in any media, which means it applies to both online communications as a traditional legacy news publishers, and those publications need to be published under the initiative, control, and editorial responsibility of a service provider. This is quite of a broad definition, so even though it has a multiple different clauses that need to be fulfilled, those clauses invite a lot of subjective judgments, and those clauses are quite open, because what does it mean that information is related to news or other topics? Other topics that basically means any type of information. So this is a bit tricky. So are there any issues with the press publishers' right? If there weren't any, I wouldn't spend a couple of years discussing that, I must admit. So there are quite many of those issues on the table, and I will discuss all those issues in reference to the implementation process. So as I mentioned, implementation process is still ongoing. At this very moment, press publishers' right has been implemented in 9 member states, and I apologize for this map because it misses Croatia, which I realized only after I inserted it there. The author kind of forgot about one country. Croatia is actually one of those countries that did implement press publishers' right already. We also have a multiple of drafts on a table, so we have 5 drafts that are already in the parliaments of member states, and other that were made publicly available. And as you see, we still have a couple of white dots, and one of them is our host country of Poland. This is because the implementation of press publishers' right in Poland hasn't been made publicly available. Maybe there is a draft, we don't know, because it hasn't been made available to the public as yet. So only 3 countries are lagging in here, Poland, Greece, and Latvia, that those drafts are not on the table. So rest of my presentation, I will be basically building on a draft, building on implementations that are already made available to the public. So what are the issues, or what the issues is implementation showing? Unfortunately, I will continue the theme of the first session, saying that in theory we have harmonization, but in practice not much of harmonization is actually happening, and the implementation kind of emphasizes that even further. So when it comes to a basic concept of the press publishers' right, so a press publication, member states implement that provision simply copy-pasting. So this broad definition that we have on a table, nothing really happens with that. And I think it's important to remember that the definition of a press publication and copyright and neighboring rights in general are kind of ambivalent when it comes to the quality of works that they are protecting, which means that even though the argument for the press publishers' right was that we are trying to protect quality journalism, a definition of a press publication doesn't recognize if journalism is of qualitative nature or what is the quality of it. So basically, fake news or disinformation and qualitative journalism will meet the criteria of this definition, and member states couldn't really do anything with that on an implementation level. So what they are doing, they are copy-pasting. The other thing that they are copy-pasting is also the rights holder. So who holds the rights? And in here, the directive basically hints that, as you now see on your screen, this is a service provider, such as news publishers, news agencies, and so on. So most of the member states do copy-paste. However, we have those examples in Croatia and in France when national implementations try to link to how a press publisher is defined in the press and media law. So they are saying that only those that meet the criteria in the press and media law of a member state can benefit from a press publisher's right. Whether this is consistent with the directive, not particularly. However, this is the approach that they decided to take. What is more interesting from the perspective of the press publisher's right and how this mechanism or this right is being implemented is actually the scope of the right. So what our publishers of press publications are getting from this right, what actions are getting into their monopoly, and against whom and in which way they can actually enforce their rights. So this is something that I will discuss in more detail. So our publishers of press publications are gifted with 2 rights. They are getting a right of making available and a right of reproduction in extent that it applies to online uses by informational society service providers. And as I mentioned, 3 very important carve-outs from this, the scope of this right is that it doesn't apply to acts of hyperlinking, but it also doesn't apply to single words and very short extracts. However, in here we need to remember that this is a neighboring right, which means those acts in theory can be restricted still by copyright. Because even though, again, we were arguing, or European legislature and press publishers were arguing that we are introducing this right for the sake of legal certainty, we are not really solving any issues that were out there. We are simply introducing a second layer of protection. So we have copyright, but we also have a neighboring right on top of that. So certain acts are carved out, but those acts are still governed by copyright. So looking at the scope of this right, what does it mean that something is an online use? In here, there is not much of a discussion. It more or less is quite obvious to all the member states. However, some of the member states decide to expand in the explanatory memoranda that accompany the implementation proposals, basically saying that only the acts of reproduction that the end result is the online use are covered. So if something is, basically we have reproductions that are only there to facilitate, for example, crawling or indexing, this is not covered by the press publisher site. And secondly, when it comes to hyperlinks, so the right does not apply to any acts of hyperlinking, and most of the academic literature, commentators and member states are okay with the fact that it doesn't cover any types of hyperlinks. So one of those elements that news aggregators are based upon, that publishers were bothered about. We have one member state that decided to be more restrictive in its interpretation, saying that only genuine redirection, so only those types of hyperlinks are not covered by the press publishers' right. This is a Danish proposal. We don't know how it will work in practice, but there is this idea in there that only certain types of hyperlinks are out. So what does it mean in practice? It means that those two, that going back to news aggregators that inspired us, we had two elements that were problematic, in theory at least. We had hyperlinks and we had short extracts of text, meaning snippets that are commonly referred to as snippets. So if hyperlinks are out, the most important in the context when talking about the scope of protection when it comes to press publishers' rights are actually those very short extracts, and to what extent press publishers' rights limits sharing of those very short extracts online. So the directive doesn't really say what are very short extracts and what should be understood by them. We only know that there is no originality requirement, as we are on the level of neighboring rights and not copyrights. So it's basically up to the member states to decide what amount of content can be freely copied without triggering the press publishers' rights. And what are the member states doing here? They are doing a lot of different things. And there is not a single approach. However, we have a broad theme of basically saying that whether something is or is not a very short extract needs to be assessed on a case-by-case basis. So member states are basically avoiding saying, oh, you can only copy 5 words and this is a very short extract, or you can copy 2 words, or you can copy whatever. We have only one exception till now, so Lithuanian proposal for implementation says that it should be okay to copy up to 200 characters. But most of the member states say, hey, you need to do case-by-case assessment, and they basically indicate a number of different factors that need to be taken under consideration when assessing, making this case-by-case assessment. So in here they say that this very short extract cannot lead to a substitution effect, so basically making it redundant for a reader to go to the full article because they got enough of information, enough of content from this very short extract. But they also say that this exception cannot impede the effectiveness of the right and investment that the publisher puts in the content. And a third kind of issue that is a bit problematic when it comes to the implementation of this carve-out from the press publisher's right is whether only literary or also non-literary content can be a part of a snippet. So whether it is okay to have a thumbnail, whether it is okay to have 3 minutes of an audio file, whether it is okay to have a short video or not. So most of the member states are very silent when it comes to non-literary content being included in a very short extract, but we have 2 examples of member states saying, so you see, Croatia says, no, you cannot, and Estonia says, yes, you can. So not much of harmonization and not much of the same approach to the same issue. So we don't really know whether we can count on this exception, on this carve-out, when we're including a photo, video, or anything else in our very short extract. And now a thing that becomes more and more problematic, and that partially links to the discussion that we are having when it comes to fundamental rights and Article 17. So as I mentioned, Article 15 and a press publisher's right is not right effective erga omnes. So this is the right which is effective only towards online uses by informational society service providers. And we're having at the back of my mind, or the back of our mind, that originally that was supposed to be only news aggregators. So the Copyright Directive doesn't include a definition of an informational society service provider, but refers to a definition that already was a part of the EU law. So as you now see on your screen, so that's basically a service which is normally provided for remuneration at a distance by electronic means at the individual request of the recipient. The directive in here puts as examples of those sort of services news aggregators, so those services that basically provoked European Commission to intervene, and media monitoring companies. On top of that, we know that it also covers search engines because that was the Court of Justice decision in the case of German press publishers' rights. And for example, Finnish implementation also indicates that in some situation, press publishers themselves can be considered informational society service providers, so their users are also covered by Article 15. And in here, it's quite important to remember that on top of this general rule that the right only applies to users by informational society service providers, to further ensure that it doesn't cover users by individuals, the directive has this next carve-out of non-commercial or private uses by individual users. And Recital 55 further specified that basically means that users' ability to share information, to share press publications online, should remain unaffected by the press publisher's right. And this is very important when we look at the current discussion on whether social media, so whether Facebook, Twitter, and other social media platforms are covered by the press publisher's right. So we do not have consensus when it comes to this issue, either among member states or when it comes to social media platforms themselves. So member states have different approaches in here. As you now see on your screen, some basically say in their explanatory memo that people are free to share their content online, but other member states say, hey, social media is also an example of the informational society service provider, thus it should be covered by the press publisher's right. Also, Facebook is not quite consistent when it comes to its own behavior, because on one hand, in June this year, they said when Danish press publishers were trying to argue that Facebook should start paying their fees based on the press publishers' rights, they changed their policies and they explicitly said, hey, we're not covered by this right. And then in October, so only a couple months later, they actually entered an agreement with French publishers saying that they will start paying them for inclusion of press publications in their news tab, but also for the press publisher's right. So my personal view on this issue is that social media is not covered. And why is that? So we need to take into consideration the fact that the content lands on social media in a different way than it finds its way to search engines or news aggregators. Because the thing is that social media are not the ones communicating content to the public or making content available to the public. It's users who use social media, and by this means they are making content available to the public. And secondly, we need to look at this exception. So if our European legislator struck in two ways, try to restrict the scope of the press publisher's right, so not to affect the ability of users to share content, first saying that the press publisher's right only concerns uses by informational society service providers, and secondly saying that private and non-commercial users are out, basically allowing or saying that social media is within the scope, we would indirectly affect the user's ability to share content online. And that from the very, very start was out of the scope of the press publisher's right when we were discussing it. And also for the third, we need to remember, as I said at the very beginning, that introduction of the press publisher's right was motivated by certain platforms. It was motivated by one certain service, so the news aggregator of Google, so it was not connected to social media in any way. So even though nowadays we have those broader discussion on regulating the relationship between press and platforms, and we talk a lot about advertising revenue. We talk a lot about the uneven bargaining position between the parties. Those elements were not a part of the discussion when this right was introduced. So I would say no to the attempts of trying to extend the scope of the press publishers' right so that it also covers social media. So when it comes to the press publishers' right, I think this is one of the hottest issues, is how you actually practically use your press publishers' right once you're a publisher. So we need to remember that Article 15 is silent when it comes to the process of negotiation and licensing. So what Article 15 does is basically to give publishers a right. It doesn't tell them you're entitled to receive remuneration. It just tells them this is a right, and on the basis of this right, you can license, you can negotiate with press publishers. So what are the member states doing in here? So some of the member states are basically, I think as was said in the first panel, just copy-pasting provisions of the directive, and they are not introducing any more solutions. But other member states are actually specifying licensing mechanisms or setting some principles for the publishers and platforms to follow when they negotiate about payment on the press publishers' right. So some of those mechanisms, and now you can see on the slide. So there are a couple of member states that allow for collective bargaining. So mostly this is for small publishers to come together and negotiate with platforms. Others say that there is a collective bargaining mechanism, meaning that there is a collective management organization that publishers can associate with, and this CMO can negotiate in their name. And they do allow, to some extent, licensing with an extended effect. What needs to be remembered, however, in here is that even if member states decide to use the collective management organization, there needs to be an option for an opt-out. We had a parliamentary question from one of the MEPs, I think that was still back in 2020, and answering this question, European Commission specified that yes, Article 15, press publishers can exercise their rights through the collective management organizations, but there always needs to be an option of opting out, because this is a right. So they have a right to say, we don't want any payment for our content, or we don't want our content to be included in a particular platform. So they need to be able to exercise their rights. And we also have other approaches that basically set negotiation principles. So obliging platforms, most of the time, not really publishers, but saying that platforms need to enter negotiation in this fair and non-discriminatory manner, and they need to respect rules of competition and do not abuse their monopoly or their power on the market. And to some extent, we also see transparency obligations. So some of the member states basically say that during the negotiation process, platforms need to disclose particular information for publishers to know how much money, how much remuneration they should be able to ask for. And on top of that, we also have some principles when it comes to setting the remuneration itself, but I'll maybe skip a bit of that. So just an example of one of the most controversial implementations that we now have on the table when it comes to the press publishers' rights, and this is brand new because I think it was published in the official gazette only last week, and this is this decree will go into force only on the 12th of December. So what has Italy decided to do? Italy has decided to change a right, so the press publisher's right, into an entitlement to a fair compensation. So what they basically said is that whenever a publisher or whenever a platform asks to enter a negotiation, there is an obligation to enter this negotiation. And if an agreement is not reached between parties within 30 days, then each party can file to the communications office, so the Italian Communications Authority, and the Italian Communications Authority will make an authoritative decision on the level of compensation. So this is quite harsh and this is quite far-reaching, and there is a there is a very engaging, very lively discussion in Italy whether this is actually compliant with the EU law and whether this is compliant with the Italian law as such. Personal opinion, I do not think so, because right is right and obligation is an obligation, and those are very two different concepts. And where does the inspiration for Italians to do that come from? It actually comes from Australia. So what did Australia do? Australia did establish the obligatory arbitration mechanism. So back in February 2021, Australia introduced its own solution to the problem of relationship between press publishers and platforms, so-called News Media Bargaining Code. And News Media Bargaining Code, I'm always cautioning against comparisons between Europe and Australia, because the solution adopted in Australia does not belong to the domain of intellectual property or copyright. This is basically a code that establishes a way to negotiate, saying that certain platforms, so designated platforms, have an obligation to negotiate with registered news providers, registered new businesses. And this is because they make news content available. And it's important to know that this is not the right of making available that we have in Europe, that we adopted from the WIPO Copyright Treaty. It's a concept that is autonomous for the News Media Bargaining Code. So it's not really possible to make those direct comparisons. And also quite a thing to remember is that all the agreements that are now being struck in Australia are not being struck according to the News Media Bargaining Code, because up to this date, not a single platform has been designated by the Australian government. So even though Australian government was planning or creating this code having Facebook and Google in mind, neither Facebook nor Google has been designated to this day. So this code doesn't apply in practice. And why in Europe all the current implementation are very sensitive when it comes to this negotiation mechanism is because what happened in France, basically. So France is a first member state who implemented press publishers' rights still in 2019, and from the very beginning, Google basically said, we are not going to pay. And how it looked like, so even before the national implementation in France went into force, Google said that it will stopped displaying content, and said that it will display content only of those press publishers who allowed them to do so on displaying content, displaying snippets. They were still displaying titles, they were still displaying links, and they basically said they will display snippets only for those that they allow them to do it for free. That resulted in a procedure again in front of the competition authority in France that, according to its interim decision, it forced Google to go and negotiate with French publishers. And we have still an ongoing case that is waiting for a final decision of whether Google refusing to negotiate with French publishers has infringed its dominant position. Going to the end. So now, what is actually happening in Europe and in the world when it comes to the deals between publishers and platforms? So back in October 2020, Google has announced its new initiative, which is a new program, new licensing or cooperation with publishers, or new product as we know it, so Google News Showcase. Till this day, as far as I am aware, 14 publishers in 14 countries has signed agreements for their content to be used as a part of Google News Showcase. What is kind of interesting in this context is, even though we have six member states that till this day has signed those agreements for their content, or publishers from those member states that signs agreement for their content to be used in the Google News Showcase, if a neighboring right for the press publishers appeared as a part of those agreements, it's a bit of an ancillary and sort of next to the Google News Showcase. It's not something that it's a main feature of those agreements, and also those agreements are not publicly available. So we sort of don't know how much money is being paid for Google News Showcase and how much money is being paid for the neighboring right. What we do know is that a number of publishers are basically protesting and saying, we don't want to sign agreements if those agreements are about your new product. We only want to sign agreements with you when it comes to the new press publishers right. That happened in Denmark, and now we have reactions from France where the competition authority said publishers have this right, they should be able to sign agreements only for the neighboring rights, and we have the proposal in Spain for the implementation that would put this requirement into the law. So the last finishing sort of what is happening with the press publishers right and how different features are being implemented is the author's share, or as I refer to it, author's share. So the press publishers' rights in Article 15 guarantees that an appropriate share of the revenue that publishers are getting will be distributed to the authors of works and other protected subject matters that are included in this informatory collection that a press publication is. So again, the directive doesn't really say what is the appropriate share or how should it be distributed, and member states are treating this provision, unfortunately, not in a nice manner in most of the time, because in most of the time we only have this copy-paste of just saying journalists should have an appropriate share. And if they are doing or introducing any mechanisms, I think now you can see on the screen that those mechanisms are vastly different. So if there is any share mentioned, this share can go between 2 and 5% in Italy, through 1/3 in Germany, to 50% that is being proposed or being considered in Poland, and also that has been proposed in Lithuania. So there is this huge dissonance because this is between 2 and 50%. So this is quite of a difference of what journalists can expect it to get. And also the mechanisms are different. So in some countries we have obligatory collective management. This is quite popular, but again, most of the countries say nothing, or they just say this is for journalists to discuss with their employer or to discuss with a person that they signed a freelance agreement with. So this is basically to be agreed between the parties. And as a fun fact, at the very, very end, so as I said, press publishers' right, in theory, very narrow, only online users of informational society service providers. And then we have a Croatian implementation that already has been adopted. So what Croatia does, they actually introduce 2 neighboring rights. So they introduce one right, which is the implementation of Article 15, and on top of that, they introduce a second neighboring right for press publishers that applies to all the uses, gives, so not only online, but also analog uses, so gives press publishers also a right of distribution, rental and lending, also in respect of library lending, and it says that this right will last for 20 years. So this is something which is not particularly discussed, but we have this anomaly, and in the official document with my nearly no Croatian and a bit of Google and DeepL, I can tell you that there is no explanation provided why they decided to introduce this extra right, and they don't really say what is the purpose of it. So just to sum up all of that just said, it was a lot of content, apologies for that. But just to say, as with Article 17, with Article 15, even though it leaves way less space for interpretation for the member states, we see that there is not that much level of harmonization, especially this is visible when it comes to scope, so are social media a part of it or not? What is the licensing mechanisms for that? Is it obligation or is it not? And also when it comes to our journalists, who sometimes get nothing, sometimes get 2%, and sometimes are supposed to get 50%. So we see what member states are doing. They're trying to broaden the scope of the right by including social media. They are seeing also those difficulties with enforcement of the right. So this is something that people who criticized press publishers' rights from the very beginning were saying that this is a right. We're just giving you the basis. That won't really solve any of the issues with enforcement of the right. And last but not least, because we have those bound agreements, so we have Google News Showcase and neighboring somewhere in there, we don't know what is the level of influence of the press publishers' right on those agreements and remunerations that are being paid, but a recent investigation by a press gazette in the United Kingdom hints that there is not much of a bearing on the press publishers' right on the level of remuneration that European publishers are able to secure in comparison what Australian publishers are able to secure. So this is all from me. I cannot move that. I cannot move that, but it will just stay. Thank you very much for your attention.
It's been extremely interesting and inspiring as well. We don't have that many questions coming from our online audience, but there are a few that I would have. First one, you said, I think you mentioned that in greater detail when you were discussing Australia in your paper. What struck me, and I'm not sure if I got it right, you said that it's the right to, it's not, the subject is not the publishings, the press publishings, but the content. This is what
respect of Australia.
With respect to Australia, yeah, you're saying something different, and you're saying it's the content that is that matters there, and not really the publications. And I wonder what's behind that.
So when it comes to differences between Europe and Australia, we have different markers when it comes to deciding who is entitled or who can benefit from a solution. So in Europe, the key for us is a press publication.
Yeah.
And Australia's solution is a registered news media.
Okay.
And in order to be a registered new media, you need to meet a set of requirements. And I'm sorry, I don't remember, I might miss them out, but there are 4 requirements, and one of those requirements relates to the content, so the core news content. So for them, the primacy is on the registered news organization, but then it has to meet certain criteria and produce a certain type of content, and the core content, as far as I remember, but apologies if I don't remember that super exactly, basically needs to contribute to the public debate. So they have this kind of a bit of a higher threshold. And also registered news organizations need to meet certain professional standards. And this is something that is not even considered in the European approach. So they have a content, they have the Australian audience test as well. So something that we have as, that our companies that are benefiting from press publishers need to be registered in the EU basically, or have a main place of business in the EU. There is also a revenue test in Australia, so there is those certain requirements. But again, all those agreements that are being struck now in Australia are not being struck as a part of this framework.
Okay.
So this is a bit tricky, because there is a lot of discussion in Europe when it comes to how we should model our approach, and also as a part of the Digital Markets Act, now we have this discussion of publishers trying to actually have an obligation to negotiate, which is modeled on the Australian, and saying, oh, this is a good way, like, see, all those agreements are made in Australia, and I'm always like, but this is not the News Media Bargaining Code, it doesn't apply.
Okay.
At least not yet.
The other problem that I have with this is, so basically the publisher's rights, it is to protect investment in press publications. That's the motive behind, to provide incentive. And how much do you think could we learn when interpreting press publishers' rights from, let's say, database directive? When trying to decide, what is this small snippet that you might use and that is not covered by the right, and what is substantial, that when you're using it you have to pay. Is there anything that we could learn from at least trying to understand what this right is all about? Because it's not very clear. I agree with you, but is there something we could learn from the database directive here, or you think?
No, definitely. There was actually a discussion back, I think that started in 2017, comparing the database directive and the sui generis right to the press publishers right, saying, yes, if we don't have the original requirement when it comes to snippet, why wouldn't we have the qualitative and quantitative investment as we have with the database directive? Though this argument I fully support, because if we are saying we're giving this right because we want to protect the investment in the production of content, and I'm not saying publishers definitely put a lot of investment in production of content, at least what we believe are quality journalism, but as an argument, that is perfect, but it was not well received on the European level and was not considered as far as I know, because these very short snippets, at some point, I think during the council discussions, the council was considering introducing this either or, so saying that member states can set the criteria either based on originality or either based on a particular amount of content that will be qualitatively representative. But this died and didn't make it even to the council compromise.
Okay. All right. And the other problem that I have, it seems to be an exclusive right. That's how it's drafted.
Yeah.
So the Italians are going the wrong way.
Personally, yes.
Yeah, that's what it seems. And you think the Croatians?
To be honest, with Croatians, I'm very confused. And I'm still, if there is any Croatian or someone who knows Croatian copyright lawyer who can enlighten me why they are doing it, I'm very up for it, because as far as I try to go into more media Croatia-oriented environment, they don't know why it happened. Because this right is very broad, and for me, it's shocking to the extent that it applies to library lending as well, which is a bit bizarre because it also captures all those situations when libraries make content available to their patrons, which is quite excessive. When it comes to the Italian implementation, I think Marco Schialdone, if I'm not mispronouncing, is a person who is quite actively commenting on that on Twitter and other media channels. So if you're interested, do follow him. And the hope sort of is, because this solution is really difficult to defend based on the directive, the right is not an obligation. So because the Italian Communications Authority will issue a decision which will set the criteria for defining what a fair remuneration is, the hope is that once they issue this decision, it can be brought to the Court of Justice. So Court of Justice in this way to kind of assess whether Italian implementation is a proper implementation of Article 15 and whether it is consistent with the EU law. So this is kind of the hope for now, but again, this is very fresh. This is last week that has officially been published, and on the 12th of December it goes into force. But as far as I see it, and from my personal experience watching the debate, in Italy the press publishers have a very, very strong position. So they were able to argue, to lobby, using this very not nice word, they were able to lobby in the parliament for this particular solution. Whether it stands, I hope not, because it's not consistent, and definitely right is not an obligation, but let's see what happens.
That's what Donald Trump used to say. Let's see what happens. We have one more question. I'll give you
This is like a lot of confront.
Hello, I'm Lavinia Brancusi from Warsaw, from Polish Academy of Science. Thank you for your great presentation. I learned a lot because I'm not a copyright specialist strictly, but I have a question regarding these last parts. I mean, regarding these antitrust proceedings who were, for instance, instigated in France. And what I perceived from your presentation is that the IP system is a failure somehow. I mean, this harmonization is a failure because we'll have a patchworked situation somehow. It can get at the end. So I'm wondering if finally this is not somehow something that it can turn beneficial, because if antitrust, it will be the last, ultimate instance to make order. It will be somehow a way of getting, for instance, Google to cut the deal, because this will be extremely punitive. Generally, how they end this proceeding, it will be extremely punitive damages for Google. So it's a question if finally it will not be again a situation when IP doesn't manage to make an order, and it's antitrust who will do it finally.
Yeah, but the case is, why do we need to have, antitrust enforcement? What is the purpose of introducing a right that cannot be enforced on its own, but needs, antitrust and needs competition proceedings? And also, I'm not an antitrust lawyer, so this is something that I know for my more competition-oriented
I think
friends.
Rafa is here the best authority to
But as far as I'm aware, France is a particular jurisdiction when it comes to the enforcement of this right, and when it comes to the assessment of the dominant position. So it's not necessarily the case that this approach will be followed in other member states, and that they have ability or even they would like to follow this approach. So this is as far as I understand, and from the commentary there is actually quite quite good working paper that came from the Max Planck Institute on this case, where the EU competition lawyers argued that this is not a proper way to enforce it, because we A, don't have the abuse of dominant position, B, there is no market failure that competition law should actually amend in there. So I can kind of refer to competition lawyers for that. I'm not a competition lawyer, but just on a very principled level, I don't think it's right to disturb a copyright system, to introduce a solution that cannot survive on its own to begin with, and then we need to have competition authorities helping us out. And also the question is, if we have those Italian solutions, if we have the collective management, I don't think the cases can be phrased even in the same way and can be, but again, this is like my hint, not a competition lawyer, so don't cite me on that for sure.
Okay.
But no, this is an interesting kind of view, but also the thing is that it will take years. Because even now with the France case, this is already 2 years and there is no decision. And no other case have been started. And we can also see, so with the German national press publishers' right, we had a very similar case with the German cartel office, and that didn't fly. So they didn't see it as an abuse of dominant position, because that was, a situation when they gave, I think that was all about giving a choice between having your content for free to all of them or nothing, and not picking and choosing. But don't cite me on that. There are national, there are other approaches that didn't go as well for press publishers as the one in France is doing. But also we have a change of the head of the competition authority in France, so we'll see how that will go, because we no longer have Mel de Silva, who is very...
You still have faith in it that, we can introduce a right and we can give a reasonable content to this right in each country. So
on a level of honesty,
and also to enforce it.
On a level of honesty, I don't think press publishers' rights should ever come into existence, because this is not a right policy decision. But I think you could read that between the lines from everything I said today.
But this is the answer why sometimes antitrust is coming, because this is, I think, a strictly political decision, mostly.
It is, unfortunately. But No, thank you
Okay.
for this.
Thank you.
You've expressed your complete distrust into this new right, and you're disillusioned. But there are people who introduced this, and probably they did it for a purpose. That's what intellectual property rights are introduced for. Sometimes, of course, in the European Union, we just introduce them to harmonize rather than achieve. That could have been the case with the database directive. Probably the only thing that we've achieved is not really incentivizing innovation, but harmonizing certain areas so that we had one solution across the EU. What do you think was the purpose here? I know it will not work. You've said that already, that you're disillusioned with this. But what, at least, anybody tried in a sensible manner to put a purpose that would make any sense?
No. I think like there is a dissonance in here when it comes to the principles that motivated the intervention and the shape of the intervention, because I'm definitely not negating the need to intervene in the relationship between press and platforms. I'm just saying that copyright is not a way to go. Introducing a neighboring right is not a way to go. Nowadays, we have quite a lot of discussions and quite a lot of people coming in the fore and saying, hey, why don't we do it through taxation? Because the problem with the press publishers' right is that we attach a lot of importance to the use of content. So if you kind of determine the remuneration on the basis of a use of content, we are just enforcing the platform dependence on the side of press publications. And when it comes to online news environment, we actually have a multitude of issues to solve it in here. European Commission is considering now the Media Freedom Act. They will also be a part of the DMA, and they're having some discussions in here. So this relationship between press and platforms is way more complicated than what our copyright directive is telling us. It's way more complicated. So I would just say it's like, we should go and actually express what we are doing, because we are trying to do is to get the advertising revenue that used to be more on the side of publishers and redistribute this revenue to the publishers. But the copyright directive is doing it in like this way, attaching to the use of content. So why not openly say, hey, press publishers are in trouble, they are dependent on platforms are making this money, let's properly tax this advertising revenue, and let's guarantee that the share of this advertising revenue go to the publishers, and spend more time saying what publishers are supposed to do with this revenue. So just say, oh, we are going to give it to those publishers that meet those and those standards, that contribute to the democratic discourse in this and this and that way. So in this way, we can kind of have more control over how we distribute this money and what this money is going to do, whether it is actually going to help our media pluralism. Because otherwise we have, so at least in Europe, we have this share that is guaranteed to journalists, whether it's a good share or not a good share, other discussion, but it's guaranteed. In the Australia, it's not guaranteed at all. So in Australia, even though we had this huge discussion and we had, we have good intentions on a principle level, but what happened in Australia is that we basically have deals between Murdoch's empire and big platforms, and this is just money changing hands, and we have no guarantee that Murdoch's empire will invest this money in production of a good content. They can just distribute it between their shareholders. So on a principle level, I think we should intervene to some extent, but just not through intellectual property and not any other solution that is dependent on the use of content that reinforces this platform dependence on a press sector.
Okay, so you're advocating some state involvement here when you say taxes.
Yeah, but I think this is a broader discussion about taxation of giants. Again, not a tax lawyer as well, so I won't speak into detail, but I think this is a better path for now from what, at least the solutions that we have on the table. So in principle, I'm not negating there was a purpose about introduction of this right, it's just not the right venue to do it.
Okay, thanks a lot. Fascinating, and could learn a lot from your expertise in this area. I think this will just open the discussion on the press publishers' rights here. Excellent comments, excellent presentation. Thank you very much for coming and being here in person. That's much easier to communicate, much easier to talk, discuss, and exchange. So thank you for that. And with that, we will end the second panel. And we'll meet in half an hour, if I'm correct. In half an hour for the third panel, which will be a more traditional panel with 3 participants, and we will be discussing fair use, not fair use, limitations and exceptions provisions in the CDSM directive. Thank you, Ulla, very much.
Thank you very much.
Good afternoon. We're off for the panel number 3. And we have 3 fantastic guests that will be discussing copyright exceptions and limitations in the CDSM directive. Our 3 guests today in this panel are Professor Tatsuhiro Ueno, Peter Meze, and Giulia Priora. I think we can see each other. Excellent. Welcome to Warsaw. Glad to have you with us from all over the world. Fantastic that we can connect. Although we would rather have you with us personally, but we understand the way the world is these days. Okay, so we'll have 3 presentations concerned with exceptions and limitations in the new directive. As I said at the beginning, this is one of the 3-4 issues that are the core issues regulated in the CDSM directive. And we have, as I said, 3 speakers. Professor Tatsuhiro Ueno is professor of law at Waseda University. He holds LLB and LLM from Kyoto University. At Waseda, he's a deputy director of the Research Center for the Studies on the System of Intellectual Property Law. He's been a frequent guest to lots of international conferences organized in Europe and around the world. And most recently, he has lectured on text and data mining exemption. And he will present us a comparative view of that very important exception and limitation in the copyright law, one that we can also find in the European directive, but one that has been very interestingly implemented in Japanese law, which I think has an exception that is different from what we have in Europe. Then we will have Professor Peter Meze from Szeged University and also an adjunct professor at the University of Turku, Finland. Professor Meze is an author of numerous publications on copyright law, which is one of his main areas of interest. Also an author of a fascinating book, what we view today as a must-read on exhaustion and copyright law, and he will discuss exceptions and limitations within the framework of Article 17. So we will move to go back slightly to the issues that we've had in our morning sessions. And then we'll have Giulia Priora from Nova School of Law, Lisbon in Portugal, who was an associate professor at the Lisbon School and whose interests cover copyright, digital law, new technologies, ethics, which she lectures at Nova School in Portugal, in Lisbon, Portugal. And Giulia Priora will cover the exception for teaching and research in the new directive. We will have presentations and lectures at first, and then we have saved some time for the discussion later. We will collect questions from the audience, from those participating online, and we'll forward them to our fantastic speakers. So we'll start with Tatsuhiro Ueno. Professor Tatsuhiro Ueno, the floor is yours. Welcome to Warsaw.
Thank you. Thank you very much. Can you hear me? I hope you can hear me. Okay. So, okay. Thank you very much for kind introduction. It's a great pleasure to be able to talk to you today. Thank you, Rafael, and the organizers for having me today. So I have once visited the Polish Academy of Science and the Adam Mickiewicz University in Poznan 2 years ago. So I wish I could be there in Warsaw, but I'm very glad to be able to virtually take part in this panel. But I'm wondering if the people in the venue could have lunch or not. But okay. My topic is text and data mining, copyright exception. So I have 3 topics and 3 sections. First, I will talk very briefly about what text and data mining is. The second, I'd like to overview the TDM, text and data mining copyright exceptions from a comparative perspective. And finally, I'm going to examine the justifications for the TDM exception. So let's move on to the first section. What is text and data mining? I'm sure you know TDM is often defined as a process of deriving new knowledge from text and data. As you can see, the European CDSM directive has the definition of text and data mining. So let me take some examples. If you analyze a massive amount of medical articles, you might be able to investigate the underlying causes of health issues, and you might be able to discover new method of medical treatment. So, and analyzing a massive amount of recent books or a large number of tweets in the Twitter might make it possible to know the future trend or the people's interest, which would be valuable for business marketing. So another example is artificial intelligence. If you train an AI through machine learning using a large number of images or texts, you can improve AI systems such as image recognition AI or machine translation AI. Furthermore, AI can create works. If an AI has learned all of Rembrandt's paintings or all of the Beatles' albums, the AI can generate a new artwork or new musical work in the style of Rembrandt or the Beatles. Therefore, text and data mining can foster the development of new products and new services. However, if you conduct TDM, text and data mining, in many cases, you will copy the data containing copyrighted works or protected subject matter. Hence, TDM activities might constitute copyright infringement. Of course, we have some measures in copyright laws. However, TDM activities often entail permanent reproductions of works. And TDM activities are usually conducted in organizations or companies, so these copyright exceptions are not enough. Of course, licensing can work well in some cases. However, in case of TDM using a large number of contents, such as images available on the internet, it's highly likely that there are too many unknown copyright holders. Obviously, it's very hard to obtain authorization from all right holders. So licensing works well in some cases, but doesn't enough. That's why a specific copyright exception for text and data mining plays an important role in this regard. In fact, as you can see, text and data mining exception is now one of the major topics of heated discussions in the field of copyright law. So today, I'd like to focus on TDM exception. So let's move on to the next section. TDM exception is already introduced in some jurisdictions. The UK introduced the provision for text and data analysis in 2014. But this provision, as you can see, only applies to the analysis for the sole purpose of research or non-commercial purpose. But the original purpose, non-commercial purposes. So actually, according to the UK IP office, the research output can be used for commercial purposes. But the original purpose of carrying out the TDM must be solely non-commercial. Next, I'm sure you know, the CDSM directive has the TDM exceptions as a mandatory exception. Article 3 allows reproductions and extractions made by research organizations and cultural heritage institutions in order to carry out for the purpose of scientific research. And text and data mining of works or other subject matter to which they have lawful access. Additionally, under Article 4, even if you conduct TDM activities for commercial purpose, you are allowed on condition that the use of works has not been explicitly reserved by their right holders in an appropriate manner, so right holders can opt out. The CDSM directive also provides the unenforceability of contractual provision prohibiting TDM activities for non-commercial scientific research. In addition, the directive also prohibits the technological override for TDM. So as far as I know, some member states, including Germany, have already implemented the directive, while the others haven't yet. So as far as I know. So next, Swiss Copyright Act was amended in 2019 to introduce a kind of TDM exception. So this exception applies to not only commercial scientific research, but also commercial TDM activities. But a computer program is excluded from the exception, and there seems to be no lawful access requirement. So now, finally, let me introduce the Japanese TDM exception. The Japanese TDM exception was first introduced in 2009, which was extended in 2018. So let me point out some features compared with the CDSM directive. So first, the Japanese TDM exception is applicable to not only non-commercial scientific research, but also commercial TDM activities. And the right holders cannot opt out for that. Second, in terms of allowed acts under the CDSM directive, reproductions are allowed. On the other hand, under the Japanese law, it is permissible to exploit a work in any way to the extent considered necessary. That means an exploitation other than reproduction, for instance, the distribution and communication to the public of a training data set containing copyrighted works, can be permitted insofar as it is conducted for another person's TDM activities and to the extent considered necessary. Third, no lawful access requirement. So under the CDSM directive, it is allowed to use lawfully accessible works. On the other hand, the Japanese TDM exception has no such requirement. Therefore, even if you download a number of movies from an obviously illegal website, you are still allowed to copy them for the purpose of text and data mining. So that's why I usually say Japan is a paradise for machine learning. However, it should be noted that there is no provision in Japan on the unenforceability of a contractual provision, contrary to copyright exception. That means a contract prohibiting TDM activities would be enforceable under the Japanese law. Additionally, there is no provision on the technological override in the Japanese law. So by using technological means, right holders might be able to prevent users from conducting TDM. So moreover, the Japanese TDM exception has the proviso. So the Japanese TDM exception is applicable unless it would unreasonably prejudice the interests of the copyright owner. So for instance, the Japanese TDM exception is not applicable to a data set prepared for the use of TDM. So if we look at this slide, you can find the difference between jurisdictions in terms of purpose, allowed acts, lawful access requirement, and the possibility of contractual or technological override. I guess you may have different thoughts about the TDM exception. Some of you may feel the Japanese TDM exception too broad or not too bad, paradise. However, if I understand correctly, not a few European scholars criticize the TDM exception in the CDSM directive, and they are in favor of a broader exception. And also some of them hope that the whiteboard should consider the international norm for TDM like Marrakesh Treaty. So today I have to skip these several slides on these discussions. I'm sorry. So the problem we have to ask here is why TDM activities should be allowed. What is the justification for a TDM exception? So let's move on to the last section. So in my view, there are three possible ideas. So the first idea would be enhancing innovation and competition. So actually the TDM exception or TDM activities can foster the development of new products and services and consequently enhance innovation and competition. Of course, appropriate empirical study might be required, but the enhancement of innovation and competition can be the reason for permitting TDM activities insofar as it contributes to promoting public interest. In fact, the recital of 18 of the CDSM directive states, in order to encourage innovation, also in the private sector, this directive should provide for an exceptional limitation for the purposes of text and data mining. However, some may wonder why right holders have to give way to innovation and competition. So then the second idea would be the right to research. Recently, as you know, some scholars are in favor of a broader TDM exception by invoking the right to research grounded in the fundamental rights, right to information. So if the right to research would be grounded in the fundamental right, that might be the reason for permitting TDM activities from the viewpoint of striking the balance between the fundamental rights. So, but some may wonder why the right to research has a priority of a copyright. So finally, the third idea would be the internal limit to copyright, the scope of the copyright. So now, let me introduce the justification for the Japanese TDM exception. The Japanese TDM exception belongs to the so-called flexible copyright exception for non-enjoyment purposes introduced in 2018, which allows an exploitation of a work that is not aimed at enjoying or causing another person to enjoy a work. According to the Japanese government, the basic idea behind this provision is that copyright is a right protecting only an interest in the inherent exploitations which are aimed at enjoying or causing another person to enjoy a work. If an exploitation of a work is aimed at enjoying or causing the public to enjoy a work, such as book publication or movie screening, copyright should cover such exploitation. On the other hand, if an exploitation of a work is not aimed at enjoying, such as text and data mining, copyright doesn't need to cover such exploitation. Therefore, the Japanese TDM exception seems to be based on the idea of the internal limit to the scope of copyright, rather than the external limit to copyright as a result of striking the balance with other fundamental rights or the public interest, such as innovation and competition. So I cannot go into detail today. However, I'd like to emphasize that some scholars, including the European, try to exclude TDM activities from the scope of copyright based on, for example, the theory of a use as a work, the concepts of reasonable exploitation, or redefined scope of exploitation. Again, I have to skip so many slides on those discussions, but what I like to emphasize is that a little similar idea can be seen here, that TDM activities are beyond the inherent scope of copyright, since TDM activities do not prejudice the copyright holder's interests. They are to be protected by a copyright law. So these were three possible ideas of the reason why TDM activities shall be permitted. In my view, TDM activities do not seem to matter so much, at least for individual human authors and performers, even though TDM activities matter for enterprise copyright holders such as publishers. So I think that the enhancement of innovation and competition and the internal limit to the scope of copyright can be the reason for permitting TDM activities, and at the same time, the justification for the TDM exception. So to conclude, let me just briefly summarize my talk. TDM exception is quite important and useful in data economy. TDM activity can foster the development of new products and new services. Of course, the problem is the reason why TDM activities using copyrighted works should be allowed. We have to closely re-examine the justification for TDM exception. But I can recommend you introduce a very broad exception for TDM, like the Japanese TDM exception, which can be justified theoretically, I believe. However, I'm wondering about the latitude of EU member states in legislation. In my understanding, Articles 3 and 4 under the CDSM directive are mandatory exception. So EU member states have to introduce the TDM exception. But I'm wondering whether EU member states may introduce the TDM exception broader than the CDSM directive, like the Japanese one. Or EU member states have no choice but to copy and paste Article 3 and 4 into your national laws. That's my question. Considering that the InfoSoc directive provides for the exhaustive list of exceptions and limitations in Article 5, it seems negative, I guess. But I would be happy to hear the opinion from European scholars about this point. Thank you very much for your attention.
Thank you very much, Tatsuhiro. That has been an excellent presentation, really touching upon the very fundamentals of copyright. I very much like the idea that there is internal limitation to copyright. It really speaks to me, and it really counters the tendency that we have in copyright to think of reproductions in a very technical way, with this link to the purpose of copyright being missed, in fact. And I think that is part of the problem. This explanation is really very interesting, and I have a lot of sympathy for that. So very many thanks for this excellent presentation. It really adds to our understanding of this exception, but copyright law in more general terms, and to the understanding of the reproduction as one of the fundamental, I should not use this word, one of the main rights, one of the main copyrights that we have. Thank you very much. We'll come back to you in the Q&A time. Now we will move to Professor Meze. Welcome. It's good to have you with us. And the floor is yours.
Thank you very much. Could you please confirm you also hear me? Because as we have seen, there were some technical issues before. Well, I hope, at least I suppose. I only see myself, so I don't know whether I will receive any response from anyone at this point. Thank you very much for the invitation, Rafael. It's my pleasure to, by the way, finally see you we almost had the chance to meet earlier this year in Szeged in my university's conference. But thank you very much for giving a chance to me to meet you this year, and also to meet the audience, both in person in Warsaw and over the YouTube. As you might see, today I'm going to talk about limitations and exceptions and Article 17 CDSM. Nevertheless, this
just to confirm, Peter, if I may, just to confirm, the slides are perfectly visible, we can hear you, everything is okay. So no technical problems on our side. Sorry for the interruption, but everything is okay.
No. It's very good. I would hate to start everything from the beginning, because I won't be able to do it again. So in any case, today I'm going to talk about limitations and exceptions in Article 17 in a very special way. I am certain that the general audience today has already read several times what Article 17 is speaking about, so I'm not going to discuss the doctrinal dimensions of the limitations and exceptions and this article, but I'm going to introduce to you some comparative and empirical findings that me and my young colleague in Szeged, as well as in collaboration with Joao from Amsterdam, have carried out within the frames of a very important European Union funded project called Recreating Europe. I have to click, I have to learn this. As a few notes with respect to the foundations and basic ideas behind our research here. Of course, whenever it's about the platform age and whenever it's about the regulation of the platform age, we cannot forget thinking enough about the magic keyword of copyright law, which is the fair balance between the interests of the various stakeholders. CDSM, including and especially Article 17, has tried to take steps towards balancing the interests of both right holders, intermediaries, and end users or consumers as well. At the same time, Article 17 has introduced a system which is per se designed to be a combination of obligations for private parties, private platforms, and also obligations under the law, and obligations on them that they have to carry out privately within the frames of their end user license agreement. This system is therefore a complex system which has to be analyzed, in our opinion, not only on a dogmatic level, but also on an empirical level. We have also spotted with my colleague that the literature with respect to the comparative as well as empirical aspects of these questions related to platforms and end user flexibilities, as you will see that I will use this expression, is very much limited. So we wanted to contribute to this field of literature within the frames of Recreating Europe. And as such, we are carrying out two main tracks of our research within two different types of work packages of Recreating Europe. The first one is focusing on the comparative legal perspectives of the legislative framework of the Article 17 with respect to intermediaries and as such, of course, with respect to end users. And the second point, which is carried out in another working package of Recreating Europe, is focusing on the empirical evidences related to only end user flexibilities. Let's start with the comparative research here, although I must stress that this research is going to be carried out in two main phases. The first phase is already completed. The second phase is under planning, and it will be carried out next year. But as you will see, it's with purpose. It's very much connected to the time frame of the implementation of the CDSM directive. Within VP6, we have focused on intermediaries in general. VP6 is on intermediaries in Recreating Europe. Therefore, the questionnaire we put together with István, my younger colleague, and Joao from Amsterdam, is focusing on multiple aspects of intermediaries, again, including the end user perspectives of the platform age. The first group of questions were related to the hosting service providers as users. From this bunch of questions, you might see there are a couple of findings on the screen. I only wanted to focus on a few pieces. The most important one is indicated to you with a diagram as well. One of the questions was focusing on whether good faith hosting service providers are liable under civil law for the contents uploaded by their users. It's a very important thing because platforms are functioning in a way, of course, to allow end users to act with their the service providers' infrastructure. And we had to carry out a research on the question whether platforms are directly liable for end users' activities or not. Very interestingly, the findings in our research indicate that there is a significant difference with respect to the pre-CDSM period related to this question. There were a couple of countries that answered with an absolute clear yes. Some countries stressed that liability stands in line with the e-commerce provisions, and a couple of countries have highlighted that there is no direct liability at all. In some terms, let's say this way, the general liability that these service providers might face in the majority of the member states can and practically do force them to reconsider what they do with their systems, what they allow for the end users. With the CDSM directive, things will slightly change, of course. We also had a group of questions with respect to hosting service providers as intermediaries. We also, again, raised the question whether intermediaries are liable indirectly for end users' activities. Here, the major finding was more convincing. 70% of the countries confirmed that there is a clear yes to the question. Very interesting, therefore, there is much more countries with indirect liabilities than direct liabilities. Nevertheless, if you take a look just below, the next question was related to the chances of platforms, to the acts of platforms, whether they are willing to take steps against end users' illegal behavior or not, whether they do content moderation or not. And very interestingly, our findings showed the most divergent answer or solution to this question, to this issue. There were at least 6 different types of answers to the question, ranging from statutory provisions to internal mechanisms to duty of care solutions and to mere no answer as well. In other words, again, CDSM directive introduces a totally new regime for at least a handful, but I would say the majority of the European countries with respect to content moderation. Here is the third bunch of questions, which is the most important for us today. We also focus on what users might face under the pre-CDSM legal status quo in the 10 selected member states subject to this research. The first question received a unanimous answer with respect to the liability of end users for uploading contents to intermediaries. The answer is not surprising. 100% of the countries confirmed that end users are liable either or under the concept of communication and or making available to the public right. What's much more interesting is that almost no countries could report civil law liability case law with respect to end user uploads, which is very interesting in our opinion. As you all know, Article 17 is focusing on, expressly focusing on various limitations and exceptions from quotation, criticism, and review to the parody, caricature, and pastiche provision of the InfoSoc directive. Under the CDSM directive, these have to be mandatorily implemented by the member states, and these are at least those limitations and exceptions that must be defended by intermediaries, hosting service providers as well, with respect to the end users' activities. Very interesting, we carried out a research on the question whether countries have already had these exceptions in place. As, by the way, reported at other places, especially on blogs as well, parody exception wasn't heavily implemented in the majority of the member states. It seems so, at least with respect to those countries we have focused on, that this could not be accepted anymore. So member states have to implement parody exception as well. What's much more interesting is how member states treat the limitations and exceptions. As you have seen it, especially in the directive, but also in the Commission guidance, the expression of and the concept of user rights with respect to limitations and exceptions, at least within this framework of Article 17, has been confirmed. Something which has already been mentioned by the Court of Justice in earlier cases seems to become a reality, that limitations and exceptions will be treated as rights, user rights. We nevertheless raise a question to our national reporters whether that's already the case, or that was already the case in the pre-CDSM world. And very interestingly, the answer to this question was mainly negative. The majority of the countries argue that the limitations and exceptions are mainly defenses rather than affirmative or substantive rights. I must again stress that this research was carried out earlier this year, especially in a period when only a very small amount of countries have taken serious steps with respect to the implementation of Article 17. So whatever you see on the screen at the very moment indicates a certain glimpse of the implementation hunt or that process. Since then, of course, much more countries have done the implementation of Article 7. Within the frames of Work Package 2, we also carried out something we believe useful, because we were trying to test empirically how selected intermediaries reflect end-user flexibilities. To be certain, we are focusing here in this research on end-user flexibilities. End-user is quite an easy concept to understand, but flexibilities is a little bit different expression and concept than what limitations and exceptions might mean. I have to stress that in this research we focused on multiple dimensions of end-user, I don't call them rights in general, but flexibilities, chances, not only the statutory-based exceptions and limitations, but we also focused on certain other internal limitations like duration and collective rights management. And very importantly, something which is also present in Article 17, the procedural safeguards of end users with respect to the use and with respect, by the way, to the taking down or removal, filtering of their contents from the platform's system. We have to admit that we spent quite a lot of time with the theoretical and the empirical framework. I'm not willing to waste your time with the theoretical issue here, but I might stress that we have done a quite detailed setting the scene activity before doing the real research. We selected various systematic, so we carried out a systematic and qualitative analysis of plenty of platforms, as you will see it on a very on another slide very soon. We grouped them into 4 main groups of platforms, and we also focused on their end-user license agreements with respect to 15, originally 15 variables. We have to admit, almost half of these variables were dropped at the end of the research for one simple reason: there was no comparable data with respect to questions like citation or parody provisions. Which is partially understandable, and in some way this is also an important finding, that end-user license agreements were practically silent on multiple flexibilities, especially limitations and exceptions before the CDSM directive was implemented or at least requested to be implemented in member states. In any case, ultimately, we could carry out an analytical research of 8 variables, which are all connected to end-user flexibilities, extent of end-users' access rights, provisions on the restricted uses, express provisions on the restricted uses, allowance of UGC, so whether end-users can upload UGC to the given platform. We also checked the license terms that end users grant to the platforms or other users of the contents via the platform. We also looked at the technological restrictions on access. We also looked at some kind of secondary dissemination activities like family sharing or other type of transfers, including my favorite topic, just as Rafa mentioned, exhaustion, whether platforms allow for resales. We also looked at the modification of terms and conditions and termination agreements, and termination of the agreements, and we also looked at the procedural safeguards. Well, maybe only for our internal purposes, but we decided to grade these platforms with respect to the variables as well, and we call it as a flexibility index. We graded them on a 1 to 5 grading scale. Just a glimpse here, we were focusing on platforms that we categorize as streaming with hosting services, streaming without hosting services, online marketplaces, and social media. Of course, I have to highlight plenty of platforms might have various functionalities. Even Disney Plus allows hosting of tiny contents, but not necessarily the copyrighted works of third parties. So actually, we tried to group and actually list the listing service providers to the given group which fits their functionality or their purpose the best, actually. Here is the overall score that we gave to these platforms. Maybe for the first sight it's hard to oversee, but let me help you a little bit. The colors try to help, of course. The reddish, orangish, whatever color is going to show you the social media platforms. The yellow ones are focusing on the streaming portals with hosting service functions, and the blue ones are the marketplaces, and very interestingly, the green ones are the streaming portals without hosting service providers. You can probably see it very well that the top-ranked service providers are the social media platforms in our understanding with respect to the flexibility of their end-user license agreements. Yellows are quite strong as well, and very significantly, the green platforms are in the second half, and by the way, very close to the end of the flexibility index. Well, this is of course just an index, and the paper we wrote with my young colleague includes a more detailed analysis of the index, but because of the lack of time, I'm not going to dig into these numbers here. What I want to show to you very shortly is 3 groups of ultimate findings we had. The first group of findings is related to something we call UGC effect, or very shortly, the UGC, the relevance of UGC. In short and very simply, we believe that we could evidence with the help of the empirical collection of data that those platforms are the most flexible, that allow for UGC hosting, the hosting of UGC content of third parties. Of course, flexibilities come with obligations as well, and of course these platforms understand that they have to introduce a technological framework that does not allow everything. Practically, there are internal technological limitations with respect to the use of UGC, both on the side of uploaders and on the side of final users, final end users. Very importantly, we found that these platforms are quite open and have a quite detailed setting on the notice and takedown procedures, but they are quite shy on addressing complaint and redress mechanisms. In other words, we believe we will find something novel here in the terms and conditions of the platforms with respect to complaint and redress mechanisms, because they are almost generally silent on this field. On this level. Amendments and terminations are asymmetric in favor of the platforms. End users either use or give up using the entirety of their content. So if they want to terminate their account, they have to accept that some contents might still remain alive on the system. They cannot negotiate on various aspects of termination as well as amendments. Terminology is a little bit misleading with respect to sales. This is something that was researched heavily by people doing research on exhaustion. I'm not repeating this, but here's a final point I have to make with respect to the UGC effect. At an earlier slide, I highlighted we followed the Pascal Chapdelain's hierarchy or pyramid scheme with respect to end user rights in the platform age. She argued that people having full access to contents have the broadest control, and she argued that the social media platform users have the most limited flexibility or broadest rights over the platforms. We believe that our empirical findings indicate that this categorization from her or ranking is not necessarily correct. We believe that platforms with UGC grant the broadest rights for end users, especially social media platforms, and then streaming service providers with hosting functionalities. The second group of issues are related to something we call regulatory lock-in effect. Of course, plenty of activities are regulated by copyright law, and therefore platforms have to comply with public rules as well. This is the reason why, of course, social media cannot be extremely open either, because significant provisions are relevant for their functioning as well. And that will be even more certain under the CDSM directive. We also spotted that there are significant changes with respect to the end user licenses as well as the code in general of the platforms due to case law, especially stemming from the United States. Embedding of contents from social media is going to be less and less possible. The death of the server test in the United States is a huge question over there. And since the major platforms are mainly Americans, at least those platforms used in Europe as well, American legal changes have relevancies for the technicalities, the technical functioning, and therefore legal functioning of platforms as well. On freedom of expression questions, or really freedom of expression related limitations and exceptions, we believe that the end user license agreements should, so in this field, they should develop. They are quite silent on talking about parody, quotation, etc., etc. So there will be certainly changes. And finally, as a last point here, we call it business flexibility effect. We believe that although end user license agreements are mainly as-is contracts, there is, and therefore end users are almost unanimously unable to negotiate on the details of the contract. But we notice that end users are still competing with each other in terms of their terms and conditions in order to generate a more compelling environment for end users to enjoy the content. They go, in certain cases, to the walls with respect to flexibilities like family sharing in certain situations, just to name one example here. A final slide here. This is the team that is working on this project. And another final disclaimer, whatever you heard now is the first phase or first part of our major research. To be out either in mapping reports or scholarly papers very soon. But we are going to continue our research next year. And so we will have something novel to say about platforms, so legal provisions on platforms in the member states, as well as in private ordering mechanisms of these platforms post CDSM implementation. Thank you very much for your attention.
Thank you very much, Peter, for sharing with us the initial results of your research. It's excellent and inspiring for the future discussions, also for today. So if you can stay with us, would be fantastic. We will come back after hearing from Giulia Priora, who is our guest from Lisbon today, I think. Yes. Welcome. Welcome, it's great to have you with us. And Giulia will cover the teaching exception in the CDSM directive. And after Giulia's presentation, we will have a discussion. So Giulia, the floor is yours.
Thank you very much. I hope you can hear me well. I didn't get the chance to test, so I hope it's working, but I see everything has been very smooth and functioning. And I want to thank once again the organizer for the invitation. the audience for being with us, and the speakers who preceded me for such insightful presentations. It's really very nice to participate in this event and in this panel specifically, not only because of the timely relevance of what we are discussing, but also for the thought-provoking considerations that were shared, and I really look forward to the discussion. So I will try to keep my presentation very brief. I will be presenting for the next 5 to 10 minutes my own view on Article 5 of the new copyright directive we have in the European Union. And I have to admit, Article 5 is not only one of my very own personal favorite provisions of the directive, but also a topic on which I had the pleasure to work and discuss extensively with several colleagues over the past 2 years. And I still currently do so with some of the speakers we have also today at this conference. So I think most importantly, for the sake of our discussion today, we need to realize that Article 5 is a provision that has a lot to tell us if we take the time to look at its legislative wording and beyond its legislative wording. And I will try to sum up for you the observations that we can draw from this provision using 4 main keywords. The first one is mandatory. So we already heard from previous presentations today that the CDSM directive fundamentally introduces mandatory exceptions, which is quite a novelty for EU copyright law. Actually, it's not only a novelty, but quoting Professor Séverine Dussolier, this marks a real transition within the regime and conception of copyright exceptions. And here I quote, a transition from from a conception as mere limitations of exclusive rights to proper enabling devices sustaining socially benefiting uses of works and creation, end quote. Along with the text and data mining exception and the cultural preservation exception, on the text and data mining, we had a masterful presentation by Professor Ueno and a critical analysis of it. Cultural preservation is another provision where a lot of attention can be drawn and can be paid also within the systematization of this copyright exception within existing exceptions at the national level. But alongside these 2 provisions, thanks to Article 5, DSM directive, we now have a specific exception for digital teaching activities, an exception that applies in all 27 member states and cannot be overridden by way of private contracts. This is a development, in my view, to be welcomed, not only per se as a policy or a legislative design choice that we might prefer for Europe or we might consider fitting for the European scenario, but also, and most importantly, I consider it to be welcomed because it is an effective solution to the deep fragmentation we experienced when it comes to teaching exceptions in Europe. So it has been thoroughly studied and displayed by several researchers, several efforts, commissioned studies released by the WIPO, Recreating Europe as a project and consortium, Communia as a association working also in this field are great examples for this. What has been displayed and proved is that the pre-DSM scenario on harmonization of teaching exceptions was deeply wanting, to say the least. This is not because we faced a neat divide in Europe between member states that decided to implement a teaching exception, picking it from the list of optional exceptions in Article 5 of the InfoSoc Directive, and those member states who didn't want to do so. This was not the case. Surprisingly enough, or maybe unsurprisingly enough, the fragmentation stems from divergent interpretation across the member states of what specifically can be permitted under the purpose of illustration for teaching purpose. In other words, what and how much is tolerable as a free use for teaching and learning environments. Here we have a little lesson to be learned. Since now with Article 5 and its mandatory nature, we have the legal certainty that all member states provide for a digital teaching exception, but what digital teaching really encompasses might still remain subject to national variations. What we know for sure is that the activities and uses of protective materials, in order to fall within the scope of Article 5 and be therefore permitted, must occur under the responsibility of the educational institution and via secure electronic systems, something on which, and here it's very important to highlight, schools and universities need to find themselves not only equipped as of today, but also ready to keep monitoring in the long run in the future. The second keyword I'd like to bring to the table today with regards to Article 5 is the word licensing. So this aspect is crucial to understand the harmonizing potential of the norm itself. In fact, despite its mandatory nature that I already presented to you, Article 5 also allows member states to make an exception to the exception. So it carves out room for market-oriented logic to prevail over the free use of protective materials in educational environments. These options enables member states to exclude from the scope of the exception certain types of works or certain uses of works for which a reasonable and easily accessible license is available on the market. And this formulation could easily embrace the whole bundle of materials that a single teacher is planning to rely on for an entire year of lecturing, exam preparation periods included. So this trade-off between copyright exception scope and licensing possibilities has been suggested by the EU, but has met with national legislator also difficulties in grappling with this choice. So debates and puzzlement arose very, very early on in the history of the DSM directive. And questions like how to guarantee a minimum core of harmonization and effectiveness of the digital teaching exceptions were pretty much a common thread in the specific debates on teaching exceptions back in 2016, 18, 19 until the adoption. And also, who gets to decide whether the licensing offered onto the market are appropriate? That's a question that mostly remains unaddressed by the DSM directive itself, and national legislators right now are trying to build sustainable responses to queries and practical problems like this one. The decision of what to do is not easy. National parliaments are showing to us also some difficulties in this regard. I bring to you the example of my own home country, Italy, which has recently transposed the directive in full. And during the drafting process of the DSM directive in Italy, the application of this licensing carve-out changed from applying to any use for which a license is available to sheet music and educational materials for which a license is easily available. So this displays to you the difficulties also in drafting a transposition of such a provision. I said at the beginning that I have 4 keywords for you to fully decrypt the relevance of Article 5, so we have now 2 more keywords to go. One is cross-border. Here, I believe, lies the real core meaning of what we refer to as the process of modernization of copyright in Europe. One of the most significant contribution Article 5 brings to the entire EU copyright legal framework is the introduction of a legal fiction, or in French we would say an escamotage, of the principle of country of origin. Laying down fictitiously a little flag on the map and binding the online use of protected material to the country where the education institution is based, Article 5, I believe, courageously moves a step forward towards overcoming the anachronism of the territoriality of copyright entitlements in the digital era. I think on this there is little left to say, except that probably this choice by the EU legislator with Article 5 points at one of the viable options that we might have and explore in the future to move past the territoriality of copyright to better address the needs of the online environment, from a broader application of the country of origin as it is in this case, to fantasizing about a EU digital copyright code in the future. And finally, because I really want to leave time for our discussion at the end and Q&A, I have a very last keyword, which inevitably is education. And hereby, I want to conclude by posing two questions and also sharing for the purpose of the discussion with the panelists and the audience. And by posing the question, I also start sharing with you which are my short answers to them. So with Article 5, the first question I would have for you is, have we moved the spotlight on the long-standing and often overlooked problem of defining a specific fair balance between copyright and education, or copyright exclusivity and right to education? And my short answer would be yes. The debate that the DSM directive has stirred up and brought to multiple tables, not only the academic one, and a debate that only in some occasions, but in a meaningful way has embraced also Article 5 and some aspects of it, has helped making the heading copyright and education, or making this complicated relationship more on the news, on the debate, on the public awareness level of discussion. So maybe it didn't become the protagonist of the entire season of copyright reform, but definitely I would call it a starring character of this story. So I would say that there is something to cheer and to cherish in bringing the discussion on copyright and education, also in light of the fact that we had occasions in the future, and I'm referring particularly on the rank of decision of 2018, where we could have probably exploited even more the occasion of talking and exchanging ideas, both at legislative, stakeholders, and public levels, on how to fairly balance our legislation. And then the very final question that I would like to share is, thanks to Article 5, do we know a little better whether, how much, and how to use protected material in our schools and universities? And here I must regret and I must admit I'm a little bit less optimistic, and my short answer would be probably not. What we know is that despite the digital infrastructure being used, the idea of education that Article 5 promotes is still an idea of education between the school walls, between the physical responsibility, no, not the physical, but between the responsibility of a certain institute, leaving little imaginations for us to draw on analogies with the private studies or education outside schools, educational activities outside universities. And I think on to have and to reach the legal certainties we hope for in terms of what falls within the scope of this new provision, what we might expect, and here I don't wish an overwhelmed Court of Justice of the EU, but I think that's realistic to say, we might expect some guidelines and some uniform interpretation stemming from the court in Luxembourg with regards also to the definition of digital teaching activities, or even more specifically, probably sharing with us autonomous concept of EU law to better define the extent to which the educational purpose limits Article 5, now that it has become a reality. And I think on this bittersweet, realistic, and fairly optimistic note, I stop and I thank you once again for your attention, and I really look forward to the panelists' comments and questions. Thank you.
Thank you, Julia, very much for this interesting presentation. We do have some comments from, if there are no comments from the audience here, a very limited audience, I must say, but no, as for now, we do have some comments from our colleagues present online. One of the questions comes from Żaneta Pacut, our colleague, researcher from Polish Academy of Sciences, the Institute of Law of the Polish Academy of Sciences. Żaneta is basically, she's commenting and asking a question directed to Tatsuhiro. Thanking for the interesting presentation. Żaneta asks, what is the reality in Japan as regards the possibility of technological/contractual overriding of TDM exception? Is it a frequent practice? And then is adding to this that Żaneta is wondering if this possibility may to some extent undermine the very broad paradise-like TDM exception in Japan. So technical and contractual overrides in practice and how that affects Japan as a haven for TDM research and TDM activities. That was also a question that I wanted to ask. If you've experienced a lot of TDM-related activity, TDM-related investment, TDM-related studies, etc., etc. Because you've implemented that quite some time ago, prior to what we did in the European Union. So I wonder if there are some empirical, practical effects of that regulation. But one of the reasons we were having this discussion in the European Union, I think, with Articles 3 and 4, was that we are, by adopting the regulations we've adopted, we are not giving ourselves a chance in that competition globally, but we're limiting our possibilities. So that's one of the questions from Żaneta and partly from me. I have a question also for Peter. One, it's always very much interesting to me. I can only cover on a tiny aspect of your presentation. The reference to Article 7 and 9, and the fact that we now have selected limitations and exceptions. We have singled out, a few relevant to the context of user-platform relationship, and we've said they're mandatory, and we've also said that these are user rights that you can protect in the courts, and that the member states must provide, probably at some stage, a dispute resolution mechanism out of courts. But then there must be, at the end of the day, you must be able to go to the court and enforce that. Now, one question would be, does it change much Is it a revolution to say that these are not mere defenses anymore, but that these are actual rights, affirmative rights that you might enforce in the courts? And if yes, why limit that to the user platform context? Why not have it for all exceptions? Is it justified to have this special relationship for the user platform context, or should we go further than that? And maybe it's you know, a reason for rethinking that nature of user rights. This is coming up here and there. I think the term came up in Canada from the Canadian Supreme Court in one of the decisions that we're talking about user rights. Now it's in the statute, so it's relevant. I mean, we care what the legislature says and must draw conclusions from it. How do you think this will affect the landscape, the user right holders landscape? That would be my question for Peter. And I have this observation for Julia that you mentioned this interesting article which leads us to the source country. I think it's 5.3. That's very interesting. I know we've been trying to have source to have one law governing copyright in multiple choice of law regulations, have not been successful to do that because of the differences, and now there seems to be some room for genuine law of the country of the source solution once we truly harmonize the law. So that's certainly a very interesting development. One that would probably make it easier at the conflicts of law stage and choosing the law applicable, not having to deal with many laws as we have to do now. Okay, I give the floor. I think we'll start with Tatsuhiro and then Peter, and then Julia, if you'd like to comment, probably in that order. So Tatsuhiro, the floor is yours.
Yes, thank you very much for your questions. And first of all, I'm very happy to see you again here, even online. So the question relates to the reality and with regard to override, technological or contractual overrides. So as I mentioned before, there's no provision in Japan on the enforceability of a contractual provision contrary to copyright exception. So a contract prohibiting the TDM activities would be maybe enforceable under the Japanese law. And there's no provision on technological override in Japan. So likewise, can prevent users from conducting TDM by using a technological measure. So that's the big problem. So as you pointed out, that might undermine the broad TDM exception. So I don't know well about the reality, but in terms of technological override, under the Japanese copyright law, even circumvention of technological measure would be allowed. So under Japanese law. So if you can circumvent the technological measure, you can conduct TDM activities. And in terms of contractual override, so right holders, to be honest, in my understanding, right holders don't recognize the importance of big data or the value of analyzing data. So as far as I know, right holders have not frequently such contractual override, But the government, exactly saying, the Ministry for Economy recently organized a study group on the overridability of contractual or technological, also override. And I chair the meeting, so very recently it was organized, and we had already 2 meetings, and we argue this problem, and we examine the possibility of interpretation that the code consider the contractual provision contrary to copyright exception, in particular prohibiting TDM activities, as invalid based on against the public policy under civil law. There's no explicit provision, but the civil code has a provision for public order. So far there is no discussion to introduce an explicit provision for contractual override. In my opinion, the Japanese government should introduce an provision for contractual override. So with regard to questions from Lafayette, there's no empirical study or empirical study about the investment or education for TDM in Japan, but the Japanese, I believe the Japanese TDM exception is the broadest one in the world. So it must be very useful for researchers, and especially artificial intelligence researchers or business companies. So I'm always emphasize the importance of the Japanese TDM exceptions, but still not enough recognize the importance of the Japanese TDM exception. So I do hope the Japanese company will make use of the TDM exceptions. So anyway, that's a very good question. I hope that answered your question. Thank you very much.
Thank you very much. Yeah, that brings a lot of important points, both on the overridability and how you approach it. These are important issues. And also the practical side, what might happen here, how that might develop. Thank you very much. That's been extremely informative and very useful. We'll move to Peter.
Okay, thank you. Thank you very much for the question, Rafael. Actually, I have to say I reserve the right, and I don't see it as a defense to my short answer to your question, that of course it makes sense to call it a right, in my humble opinion. I don't have time to explain it in great depth here, but of course, what I see about limitations and exceptions in general and this move towards user rights issues is that copyrights are historically not, but the copyright is historically designed to focus on the right holders. And whatever exception or limitation or whatever you call it, by the way, we Hungarians don't call them limitations and exceptions, you call them free uses. So whatever you call this, all these were introduced to make a limitation on the right holders' rights, actually. As such, we could simply call end users or users' ability to defend themselves against claims of right holders. What now we see is nothing else to me than a metaphorical statement that now users have their own country. They are an entity. They can have their own diplomacy. They can defend themselves as a group. I'm not sure it will ever happen, by the way, that users defend themselves as a group. But now if you say they are granted user rights, this, of course, wouldn't mean in substance that these are equal rights to copyrights of right holders, but they would mean much stronger group of interests. It's of course interesting that you can discuss this question in a comparative setting as well. Fair use is one of the strongest limitations or exceptions, and it's never called as a user right. It's a defense, an affirmative defense in the United States, and really no one really cares about the name you call on fair use. What much more matters is the procedural role, and to a certain degree that won't change, in my opinion. The other question you had is another absolutely interesting thing, and again, I wish I could have much more time to elaborate on my answer on this field. I believe the wisest thinking is if we accept that now that things can most probably cannot be turned back, but we are still at the very beginning of this user rights interpretation. Again, now we talk about Article 17 related user rights, but in my humble opinion, you cannot switch back. You cannot turn back the trend with respect to that. Actually, it would only make sense to call each and every limitation and exception to be a user right for practical doctrinal reasons as well. I mean, parody, for example, is an autonomous concept of EU law. It's in the InfoSoc directive now. What Article 17 says that must be mandatorily implemented as well as taken into consideration in the OCSSP environment. But this is still the same concept. And that might be relevant for citation and even those limitations and exceptions which are not expressly mentioned in Article 17.7. Again, this is a question which could deserve hours and hours of talk, but I believe all limitations and exceptions shall be treated as user rights. Of course, I have to think on it. Greater details, maybe there are exceptions to exceptions, but still, I believe the user rights trend is what has to stay, and we have to treat them generally as user rights.
Thank you very much. Just a thought came to my mind because I'm teaching students on civil law and I'm teaching them on the concept of subjective right. And of course, if you look at a subjective right and from a theoretical civil law perspective, then a defense is one of the types of rights. So just saying that it's a defense, I mean, from a theoretical Polish law perspective, it's a right from the start. It's just this type of right, a defense. But still, it's if you looked from that perspective of our national law and the doctrine and civil law, that would be a right anyway. It would have a special content, special meaning, could be applied in special circumstances as a defense, exactly, but that would be called a right in our civil law, whatever we do. Okay, well, thank you very much for that insight. This was many topics covered. We're running slightly out of time. I just wanted to give the last word to Julia. For comments, remarks.
Absolutely, I will be very brief. I also thank you for the comment. I cherish the fact that you agree with me. The application of the country of origin is one of the main takeaways and positive developments we have with regards to Article 5. Let's just not forget that despite this being a positive development, well, we have it because we have an unharmonized or a not fully harmonized copyright scenario, which is due to the fact that the EU legislator has a limited competence in this regard. So we have now a little bit the paradoxical situation of having a digital teaching exception fully harmonized and an analog which we don't know if it can fully include the digital uses or not, but an older InfoSoc teaching exception which cannot be fully harmonized. So that's the situation we have, but I agree with you, country of origin has definitely things to give us for looking ahead in a sustainable way. So that's nice to know that we are on the same page on this.
Of course. well, I wanted to thank you very much for this and thank all participants of our earlier panels. We thought of this event as we will put the event down to paper now. We'll share with you for your authorization, if you don't mind. We'll try to do as fast as possible. But we, of course, thought about the event as something that is an important element at this stage in our country, where we are in the midst of the process of implementation of the CDSM directive. And I think that this discussion with colleagues from outside, whose experience is far greater, and who have this comparative experience and knowledge of what's going on in Europe and where things go wrong, where things go the right way, and how we see the various countries proceeding with this very, I would say, complicated, messy, difficult directive in copyright. So I think this will be very helpful in this process, and we will try to share this with the colleagues at the ministry so that they have a chance to maybe think over the issues before a final proposal for the Polish implementation is made. So I think this will be very one of the practical consequences. But I'm also very happy for the academic discussion that we have had here. It's been very open and intriguing and informative. And I know that a lot of our colleagues participated, also some students, some doctoral students. So many thanks for the chance to of having you here and for sharing with us the results of your research. I'm sure this will contribute to the research that myself and my colleagues are doing in Poland. So thank you very much. I think at this stage, pretty much on time. I think we can call it a day. Really regret that you're not here. We'll be having some nice lunch, but this will make up once this pandemic is over, and I'm sure there will be a chance to make it up sometime in the future. So thank you, and we'll stay in touch. We'll get back, and I hope to see you soon live. I hope this day will come one day. So thank you very much, and thanks to the organizers, thanks to the Polish Academy of Sciences, to the other speakers, to our sponsors, Cyfrowa Polska, for their help in organizing this and providing the technical means for transmitting this interesting event. We will definitely have more, so either coming from the Academy of Sciences or my own university. So stay tuned, we'll be back, I hope soon. Thank you very much.
Thank you very much.